On Friday, my lord, your lordship was pleased to indicate.
If you are available at 12:30, come.
At 12:30.
We'll take it up.
Grateful, my lord.
From your other side, because
Yes, I'll inform
it is the department's mistake.
Yes.
Did I appear for the
Singh is there on the other side.
Yes, Mr. Singh, you'll be available at 12:30 because we had. Yes.
But virtually, my lord, I'll be there.
Come.
Grateful, my lord. Deeply.
May I be allowed to mention one matter, my lord? Item number 34 of your lordship's list today.
Non-commercial.
Non-commercial, my lord, not. Interim order will be expiring on 31st, my lord.
31st.
On 31st.
Let's go. 28.
Today, 28.
We mentioned it the other. Mentioning upon notice?
Yes, my lord.
Lordship, with your lordship leave, lordship, this is appeal, lordship, against revocation of clause 12A leave which was granted in my favor, lordship. There is some
Clause 12A. Section 12A.
Section 12A of the Commercial Courts Act.
Yes, you filed it.
Yes, I have already filed it.
Give the number.
There is a caveat. I have already served my learned friends.
It will be listed.
Tomorrow, my lord. If I'm grateful.
May I kindly mention a matter, your lordship, for filing it without a certified copy.
When was the order passed?
22nd July 2025 was passed by the London Commercial Court.
I have your lordship's kind leave to mention an appeal for hearing. No, this is an
Inclusion, give it.
commercial division appellate.
My lord, I need to mention one contempt application.
This bench.
Yes, Lord. Well, Your Lordship, the matter was originally from the bench of Honorable Justice, Your Lordship and Lordship Anand Kumar Mukherjee. Since Lord
Very well, yes. Give it.
My lord, may I permit to obtain a leave to file an appeal before this bench, principal bench. Before this principal bench, ma'am. My lord, original order passed by this principal bench, single bench of this principal bench, my lord. Thereafter, I am trying to file this appeal before this circuit bench, my lord. Because
Which
it's
circuit bench? Why couldn't you file?
But the circuit bench says that this appeal will be filed before this principal bench.
ঠিক এবার কেন বুঝতে পারছি না?
লিভ চাইছে এখানে ফাইল করার জন্য। ওপেন লিভ নেই বিফোর দিস বেঞ্চ। ফাইল বিফোর দিস বেঞ্চ।
এই বেঞ্চে কি রিফিউজ করেছে আমাদের এই বেঞ্চে এখন কি রিফিউজ করেছে এখনো রিফিউজ করেছে
হ্যাঁ
চলছে এটা কেন আমরা নেব?
Or the department at the time of filing, they refused to accept since there is a circuit bench and the matter pertains to that North Bengal matter.
Correct. That's right.
That is why we tried to file it before the circuit bench itself.
Yes.
But the circuit bench has also refused. So matter has to be heard before this before your lordship. So unless a leave is taken from your lordship,
yes, ma'am.
Unless a leave is taken from your lordship, I'll be nowhere, my lord. Right now I am.
No, how can we grant you leave? This you speak with the OSD, speak with the secretariat, chief secretariat. Sir, when the circuit is available, why should we entertain?
Clause 6.
They are saying that as
Trying to see the clause 6, my lord, of the circular.
Circuit bench rules 2019, my lord. The copy আছে?
No.
Clause
6, my lord. Second page, my lord. They are taking the plea. The department circuit bench, they are taking this plea, my lord. Interpretation, my lord. I really.
Please approach the secretariat of the Chief Justice, Honorable Chief Justice. Seek a clarification from there.
We are calling to mention only extremely urgent matter regarding justice.
What is the urgency?
Urgency is that I am a first wife, my all the asset and other liabilities goes to my second wife. That is the urgency. On first of August, pensionary benefit and other benefit. That is the urgency. I am first wife under
You will retire on the 31st.
My husband, my husband retired and died, my subsequently. My pension benefit
When did he die?
died, my lord, that is, my lord, in the year 2019, my lord.
Yes.
And subsequently case going on, my lord, because my
So why 1st of August? What will happen?
because of my pension benefit, my lord. My pension benefit, my lord, from the government, my lord.
If you ultimately succeed, you'll get everything back.
Kindly take it, my lord, tomorrow, my lord.
Chalo, next.
Urgent matter.
No.
For hearing of the appeal lying before the Honorable Justice Subhashi Bhattacharya and Uday Kumar.
No. Sorry, appeal can't be heard. Yes, next.
Lordship, your Lordship, my lord, granted leave to me to file this application in urgent basis, my lord, and to move on 24th, my lord. The matter did not, my lord, come in the list. Now, the difficulty is, my lord, my interim order has been vacated, my lord, by order of the learned trial court.
কেন আসেনি দেখো লিস্টে দিয়ে দাও এটা নিয়ে 5 মিনিট শোনার কিছু নেই
হ্যাঁ
On your side, commercial division bench, specially assigned matter item number 2.
Respondent, my lord. Award holder, this was being heard, my lord, by this. This was being heard, my lord, by this. And for the award holder, my lord, the respondent.
Oh.
Is that
Yes. Gas. 27% had to be blown up. Flaring. Flaring.
loan, my lord, doesn't sound
Who's the appellant?
My lord, my learned friend is the appellant. I'm the award holder. I was successful in the first court, my lord. Now, my lord, the
Very
section 37 appeal, my lord.
His 34 was dismissed. Mr. Mitra's 34
Yes.
was.
Please, Your Lordship. My lord, on the last occasion, I started off with the facts of the case. But today, after I heard, my lord, the submissions on the last 2 occasions before Your Lordship, I think I shall, my lord, change my tactics, if I may respectfully submit to Your Lordship. My lord, what I propose to do is, my lord, I am assailing an award, and I am also assailing a trial court judgment. Therefore, I will have to establish, first of all, that I am entitled to do so in view of the, amendment in 2015 of section 34 of that. So I shall try and establish before Your Lordship that section 34 as it stands today entitles me to urge the points which I am going to urge. But I think that will be easier for me also, and it will be easier for Your Lordship. Well, I will respectfully submit to Your Lordship that perhaps it will not be quite correct to say that after 2015 amendment, the Arbitration Act has become stricter in the matter of entertaining applications under section 34. I want to join issue on that. The reason being this, that if Your Lordship looks into the Arbitration Act 1996 amendment of 2015, and my lord, my lord, the amendments which have been incorporated, I would submit to Your Lordship that perhaps the courts now, legislature first and the courts thereafter, have now become much more, I should say, it has given an indication. I will not say it has granted a latitude, but I will say that perhaps the courts, or the, I should say, legislature, and therefore the courts, have become more concerned about what is the meaning of public policy, what is the meaning of misconduct, and all that. If Your Lordship kindly looks into, if Your Lordship has got the earlier act of, pre-2015 amendment, and look at section 34. I do not know whether Your Lordship will have a copy of that. Well, kindly see, previously section 34 was much shorter in dimension, and also, my lord, the extent of its operation. Kindly see, my lord, section 34, subsection 2 it remains the same. Then subsection B, where my lord material changes have been brought in. Previously subsection B was, if the court finds, subsection 2 is the previously, an arbitration award may be set aside by the court only if B is, the court finds, 1, the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, or II, the arbitral award is in conflict with the public policy of India. Well, this particular provision had given rise to a lot of legal literature in the high courts as also the Supreme Court as to what is the meaning of the conflict with the public policy of India. A number of decisions were, my lord, given subsequent to pre-2015 amendment. And my lord, the courts have expounded as to what is the meaning of public policy of India. The legislature, my lord, took note of that. And my lord, amendment which were brought about in 2015, in my very respectful submission, is expounding what was there. So it will not be correct to say that by reason of 2015 amendment, the jurisdiction of the courts have been narrowed down or had been curtailed. I will submit to your lordship, what has happened by the 2015 amendment is, the courts have now been given the legislative sanction of what has transpired pre-2015 by way of judicial decisions. So therefore, my lord, if I may respectfully submit to your lordship, perhaps it will not be quite correct to say. Now, kindly keep these two together. Previously, the explanation to subsection II of section 34(2) was, without prejudice to the generality of the subclause II, it is hereby declared, for the avoidance of any doubt, that an award is in conflict with the public policy of India if the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 and 81. Therefore, my lord, this was the very restrictive provision previously, this explanation. Now, if your lordship looks into the new act, I should say post amendment, my lord, provisions of this section, kindly see what was there without prejudice to the generality induced by affected. Making of the award was induced or affected by fraud or corruption. Now, today, if your lordship looked into section 34 of the Act, kindly come to subsection B. What was, my lord, previously subsection B? Now the subsection B has been explained what it is. If the court finds that the subject matter of the dispute is not capable of settlement by arbitration, remains the same. 2, the arbitral award is in conflict with the public policy of India. Now the explanation is, for the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if, and now, my lord, kindly see the change. The making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or section 81. This is the same thing as explanation previously. Then II has been added. It is in contravention of the fundamental policy of Indian law. That was not there. Then 3, III. It is in contravention of the fundamental policy of Indian law. That was not there. Or it is in conflict with the most basic notions of morality or justice. That was not there. Now, I ask this question to myself, why is it that these have been added? My respectful submission is, these have been added for the purpose of giving legislative sanction of the judicial pronouncements which had come before this. So this is not really, I do not accept the proposition that by reason of the amendment, the power or the jurisdiction of the court has been curtailed. No. It has been explained, and it has been, my lord, it is, my lord, as I said, legislative sanction of judicial pronouncements which had gone earlier. Then explanation 2 has come in. For the avoidance of any doubt, the test as to whether there is contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. So, my lord, here the legislature is indicating to the court that when you are looking into 1, 2, and 3, please do not go into the review of the merits of the dispute. So my submission before your lordship will be in the facts of this case, I will not take your lordship into the merits of the dispute because I cannot do so. I have been prevented by these provisions, and I shall confine myself to 1, 2, or 3, 1, not 1, 2, and 3. Then, my lord, 2A. 2A has come in. 2A was not there before. What is it? An arbitral award arising out of arbitration other than international commercial arbitration may also be set aside. Also be set aside. Can you note the words? If the court finds that the award is vitiated by patent illegality appearing on the face of the award. That was also not there. In so many words, it was not there. This was expounded by way of judicial pronouncements. I shall show to your lordship how. Then, my lord, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by misappreciation of evidence. Then, my lord, subsection 3 remains as it is. I am not going to trouble your lordship with this. Now, my lord, keeping this in mind, I will request your lordship to examine the award. On this issue of aspect of the matter, I will, before I take your lordship into the merits of the controversy, I would request your lordship to look into 2 decisions. Now, these 2 decisions I am citing before your lordship are pre-amendment act. But your lordship will be pleased to see that what has been pronounced in the earlier judgments had been incorporated by the legislature in the amendments. So, my lord, I will submit to your lordship that this is the legislature was fully conscious as to how the law is developing. So, what was a bit of a curtailment of the power, which, my lord, really entitled the court to go into the question and expound what the law is. The legislature now has laid down at what the law is. So, my lord, we come in there. My lord, first decision that I shall cite before your lordship is the decision of Bharat Coking Court. My lord, kindly see, this is a 2004 judgment of the Supreme Court. Two paragraphs I shall rely upon. First, my lord, I shall rely upon now for the purpose of showing your lordship how the Supreme Court thought about the pre-amendment, my lord, the provision of the Act itself. Well, this is reported in 2004, 5 Supreme Court cases, page 109. Kindly give me one. Cooking. Copy. Copy করে নিয়ে এসেছি। Now the one. The one. Well, may I hand up to your lordship, my lord, this? I hope these are not marked by me. Kindly give me 1 second.
We prefer marked copies.
Well, then in that event, without any thinking twice about it, I am handing up to your lordship. Well, Lord, kindly take this judgment, paragraph 11. This is a judgment of the division bench of the Supreme Court of Justice Rajendra Babu and Ashok Bhan. And my lord, this judgment was delivered by Justice Rajendra Babu. Kindly, my lord, come to paragraph 11. There are limitations upon the scope of interference in awards passed by an arbitrator. When the arbitrator has applied his mind to the pleadings, kindly note these words, applied his minds to the pleadings, the evidence adduced before him, and the terms of the contract, there is no scope for the court to reappraise the matter as if this were an appeal. And even if two views are possible, the view taken by the arbitrator would prevail. So long as the award made by the arbitrator can be said to be won by a reasonable person, well, I cannot question the arbitrators were reasonable persons, no interference is called for. However, this however is important. In cases where an arbitrator exceeds the terms of the agreement or passes an award in the absence of any evidence, kindly note these words, which is apparent on the face of the award, the same should be set aside. Well, I am relying upon the second sentence of this paragraph and the last sentence of this paragraph. Second sentence of the paragraph, when the arbitrator has applied his mind to the pleadings, 1, to the evidence adduced, 2, and the terms of the contract. So if he has done this, then my lord, he doesn't travel outside his jurisdiction. And the last sentence is that's why, however, in cases where an arbitrator exceeds the terms of the agreement or passes an award in the absence of any evidence, which is apparent on the face of the award, the same should be set aside. Well, I'm very strongly relying upon this. And I'm relying upon this also for this reason. This fact has been taken note of by the subsequent Supreme Court judgment. This particular judgment has been taken note of in interpreting, my lord, the amended provision. This is why I am relying upon this. Kindly, my lord, keeping this in mind, your lordship will be pleased to another judgment on this aspect of the matter. তোমার কাছে স্থানীয় judgment আছে? আচ্ছা, আমাকে আগে ওইটা দাও। Associate. I am showing you, lordship, the pre-amendment judgments. Well, this is also pre-amendment. This is 2015, 3 Supreme Court cases, but well, before the amendment, this amendment was not taken note of. This is a judgment of the Supreme Court, a division bench again, Justice Ranjan Gogoi and Justice Rohington Nariman. The judgment was delivered by Justice Rohington Nariman. My lord, here, the paragraphs I would like to place before your lordship. Kindly come to paragraph. Sorry. I should have given a copy. Associate. Copy 2015, 3 Supreme Court cases, page 49. Lordship will be pleased to come to para 30. This is at page 75. The odi alteram partem principle, which undoubtedly is a fundamental juristic principle in Indian law, is also contained in section 18 and section 34(2)A III of the Arbitration Conciliation Act. These sections read as follows. This section has been quoted. Para 31. The third juristic principle is that a decision which is perverse or so irrational that no reasonable person could have arrived at the same is important and requires some degree of explanation. It is settled law that where the finding is based on no evidence, note these words, and an arbitral tribunal takes into account something irrelevant to the decision which it arrives at, or ignores vital evidence in arriving at a decision, such decision would necessarily be perverse. So, my lord, this is something which was not there in so many words earlier. This has come in. Then, my lord, there are other two paragraphs I would like to request your lordship to look into. Kindly come to, give me 1 second. Well, the para 18 of this judgment. Para 18, your lordship will be pleased to find at page 67. This is, of course, with regard to conditions for enforcement of foreign awards. I am not troubling your lordship with this. And my lord, kindly after this, here, your lordship will be pleased to see, reliance has been placed very strongly, my lord, on the judgment of Renu Sagar Power in para 18. Then your lordship will be pleased to come to para 27. Here, my lord, kindly see, coming to each of the, this is at page 73. Coming to each of the heads contained in Sopai's judgment, we will first deal with the head fundamental policy of Indian law. It has already been seen from Renu Sagar judgment that violations of Foreign Exchange Act and disregarding orders of superior courts in India would be regarded as being contrary to the fundamental policy of Indian law. To this, it could be added that the binding effect of the judgment of a superior court being disregarded would equally be violative of the fundamental policy of Indian law. So these are expounding a particular concept. Which concept, my lord, was not there in the act itself earlier. Now, my lord, this particular thing has been again upheld in a subsequent judgment of the Supreme Court. If your lordship, my lord, take the judgment decision in Sanyong case, which has been cited, my lord, repeatedly before your lordship. One or two paragraphs of this I shall just refer your lordship to. This is a lengthy judgment again of Justice Rohington Nariman. This is reported in 2019 15 Supreme Court cases, page 131. I will refer your lordship to page 170. Copy that. Active copy আছে আমারটা মাত্র মানে একটা কপি কেন স্যানিয়ং এর বললাম কপি রাখতে তোমাদের এটা তো সবসময় সাইট হবে may I hand up to your lordship Malad, I am sorry, Malad, I have got Malad, may I hand up to your lordship my marked copy?
This is.
Because it seems, Malad, I have got only one copy. কপি আনো না কেন বলে দিই আমি তো বলে দিয়েছিলাম সমস্ত কি কি আমার দরকার লাগবে Lordship will please to come to para 36 I have marked here. খুঁজে পাওয়া যায় না কিচ্ছু Well, para 36 is, may I place it? Thus, it is clear that public policy of India is now constricted to mean firstly, that a domestic award is contrary to the fundamental policy of Indian law as understood in paras 18 and 27 of Associated Builders. Or secondly, that such award is against the basic notions of justice or morality as understood in para 36 to 39 of Associate Builders. Similar Associate Builders have been referred to. Then explanation 2 to section 34 to BII and explanation and explanation 2 to section 48(2) BII was added by the Amendment Act only so that Western Gecko, as understood in Associate Builders and paras 28 and 29 in particular of Western Gecko, is now done away with. So, my lord, to that extent, it has been restricted. Insofar as domestic awards made in India are concerned, an additional ground is now available. Kindly note, additional ground is now available under subsection 2 capital A added by the Amendment Act of 2015 to section 34. Here, there must be patent illegality apparently on the face of the award, which refers to such illegality as goes to the root of the matter, but which does not amount to mere erroneous application of the law. So it must go to the root of the matter. But then in short, what is not subsumed within the fundamental policy of Indian law, namely the contravention of a statute not linked to public policy or public interest, cannot be brought in by the back door when it comes to setting aside an award on the ground of patent illegality. But what happens is this: the court is first acknowledging the fact that a new ground has now been made available, but then again the court is making a self-restriction upon itself, saying that it is to go this far and not further. That is the last sentence. Cannot be brought in, namely the contravention of a statute not linked with public policy or public interest, cannot be brought in by the back door when it comes to setting aside an award on the ground of patent illegality. I am just asking to myself that any provision, I would have thought that contravention of any provision of law is something, my lord, the legislature, the parliament has set down. So any contravention of a provision which has been set down by the legislature, I would think that that will be against public policy and public interest. Because I proceed on the basis that, my lord, the legislature has, my lord, formulated and, my lord, given us the legislations in the interest of public. So if there is a contravention of any of the provisions of this, why should it not be, my lord, contrary to public interest? Anyway, this is what it has said. Then, my lord, kindly come to another paragraph. Kindly come to para 40 of this judgment. The change made in section 28, subsection 3 of the Amendment Act really follows what is stated in 42.3 and 45 in Associate Builders, namely that the construction of the terms of the contract is primarily for an arbitrator to decide, unless the arbitrator constitutes the contract in a manner that no fair-minded or reasonable person would. In short, that the arbitrator's views is not even a possible view to take. Also, if the arbitrator wanders outside the contract and deals with matters not allotted to him, he commits an error of jurisdiction. This ground of challenge will now fall within the ground added under section 34(2)(a). Then again, my lord, therefore the court is acknowledging an additional ground has been made. Then, my lord, para 41. What is important to note is that the decision which is perverse, as understood in para 31 and 32 of Associate Builders, while no longer being a ground for challenge under public policy of India, would certainly amount to a patent illegality appearing on the face of the award. So, my lord, the court says that it goes out of this provision, but the legislature has brought in another provision under which it comes. So, we cannot say that by reason of the amendment of 2015, the legislature has curtailed the power of the court. I say no, it has not. I do not see any reason as to why the court should be hesitant in, my lord, looking into an award and finding out if it contravenes any of these policies which have been laid down. Why should the court not come down heavily on that? There should not be any hesitation on the part of the court. This is what my respectful submission is. Then, my lord, kindly come to para 42. Given the fact that the amended act will now apply and that the patent illegality ground for setting aside an arbitral award in international commercial arbitration will not apply, it is necessary to advert to the grounds contained in section 34(2)(a)(3) and 4 as applicable to the facts of the present case. Then, my lord, section 43, section 34(2). The section 34(2)(a) does not entail a challenge to the arbitration award on merit. Then, my lord, the different provisions have been considered in so, my lord, these judgments I am citing before your lordship for the purpose of persuading your lordship to hold that the 2015 amendment did not bring about curtailment of the power of the court, but it had only expounded what the court had said earlier, that within the folds of this is what it means. Now, keeping this in mind, I shall, my lord, consider this particular award and place it before your lordship. My lord, I again, my lord, just want to refer your lordship to this Ahuja judgment, which says, and yes, my lord, one thing I forgot to mention to your lordship. Now, keeping in mind what I have submitted to your lordship, see, my lord, the judgment of the latest judgment of the Supreme Court, my lord, which is being cited before your lordship. In the case of Punjab State Civil Supplies Corporation, which has been cited before lordship yesterday. My lord, your lordship has copies given in the earlier judgment, in the earlier matter, but I am giving your lordship a copy to him. This is one of the latest judgment. I don't know whether this is the later or not. I always, my lord, rely upon the learned juniors for the purpose of finding out what is the latest decision, because I cannot locate these things. This is the last one that we found. Kindly come to para 13. Para 13. Bharat Coking Coal and Ahuja, which I have referred to your lordship, that has been referred. That has been confirmed, followed. Kindly come to para 13 of this judgment. In para 11 of Bharat Coking Coal versus LK Ahuja, it has been observed as under. There are limitations upon the scope of judgment. Copy reference 2024 SCC online 2632. This is para 13. Para 11 has been quoted there. There are limitations upon the scope of interference in the award passed by the arbitrator. When the arbitrator has applied his mind to the pleadings, the evidence adduced before him, and the terms of the contract, there is no scope for the court to reappraise the matter as if this were an appeal. I stop here for a moment. I am submitting to your lordship, putting it in the negative way. When your lordship finds that the arbitrator has not applied his mind to the pleadings, has not applied his mind to the evidence adduced before him, and, my lord, that not applied his mind to the terms of the contract, then the court has the scope to reappraise the matter and, my lord, look into the award. I am putting my case in that. Then last sentence of that paragraph also. However, in cases where the arbitrator exceeds the terms of the agreement or passes an award in the absence of any evidence, which is apparent on the face of the award, the same could be set aside. Therefore, my lord, if I can show your lordship that there is an absence of evidence on which the arbitrators have relied and which is apparent in the face of the award, then I can say it. I can tell your lordship that this award should be set aside. This will be my submission. Then, my lord, kindly, one thing your lordship will please to note that this is the problem, my lord, with these judgments. My lord, kindly come to your lordship sees that Bharat Coking Coal versus LK Ahuja 4 is mentioned. Kindly make a note of it. At the end of it, the reference have been given. This is a wrong reference, absolutely wrong reference. I spent about 45 minutes in locating this particular judgment last night. My lord, this is 2004-5 Supreme Court cases 109. Kindly, my lord, correct that. What has been mentioned as 2001 4 Supreme Court cases 86, that is also an LK Ahuja. But that is a different LK Ahuja. This should be 2004-5 Supreme Court cases 109. In this judgment, my lord, before I leave this judgment, kindly, my lord, come to para 15. Diana Technology, that has been referred to here, which was reported in 2019-20 Supreme Court cases, page 1. Para 24 has been quoted. There is no dispute that Section 34 of the Arbitration Act limits a challenge to the award only on the grounds provided therein, or as interpreted by various courts. This is what I am emphasizing on. We need to be cognizant of the fact that the arbitral award should not be interfered with in a casual and cavalier manner. Well, this is a warning to us, the members of the bar, that you should not attack a particular award in a cavalier or casual manner. Unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative interpretation which may sustain the arbitral award. Section 34 is Section 34 is different in its approach and cannot be equated with a normal appellate jurisdiction. Of course, granted. The mandate under Section 34 is to respect the finality of the award. Yes, we should. And the party autonomy to get their dispute adjudicated by an alternate forum as provided under the law. If the courts were to interfere with the arbitral award in the usual course on factual aspects, then the commercial wisdom behind opting for alternate dispute resolution would stand frustrated. Then, my lord, last sentence of para 25, which has been quoted from Diana. The courts need to be cautious and should defer to the views taken by the arbitral tribunal, even if the reasoning provided in the award is implied, unless the award portrays perversity unpardonable under Section 34 of the Arbitration Act. So perversity, my lord, is one of the things which had been highlighted by all these decisions uniformly. And that has now been incorporated into the new act, the amended act. Then, my lord, kindly come to the next page. My lord, kindly come to para 19, where the decisions have been referred to there, Bombay Slum Development, then MMTC and UHL, etc., my lord, are highlighted. Then para 16 has been quoted. As it is, and this is, my lord, on which emphasis has been placed before your lordship, as it is, the jurisdiction conferred on courts under Section 34 of the Arbitration Act is fairly narrow, conceded. When it comes to the scope of an appeal under Section 37 of the Arbitration Act, the jurisdiction of an appellate court in examining an order, setting aside or refusing to set an award is all the more circumscribed. Now, my lord, I pause here for a moment. My lord, I could not understand this meaning of this particular thing. My lord, appeal provision of Section 37, my lord, kindly see, there is no restriction whatsoever. I would have thought that when we come before the appellate court, we come with this, that the learned trial court should have held on the basis of the available evidence or on the basis of the acceptable law, that this should have been the finding. And when we question that, and the learned trial judge does not agree with it, we feel aggrieved, we come before the court, the appeal court. I would have thought that when the appellate court is hearing an appeal from an order or a judgment of the trial court, the appellate court is exercising exactly the same power. Why should it be? I do not know. I could not find any restriction. Of course, these are Supreme Court statements.
Perhaps what it means is what is challenged before us is not the award. What is challenged before us is the judgment and order of the learned single judge.
Right.
So we will have to examine whether the learned judge stayed within the contours of Section 34 in the sense that has not set aside the award on a ground not available in Section 34, or has declined to exercise a jurisdiction under 34 which he did not unreasonably.
My lord, accepted. So therefore, my lord, that I would have thought that is the contour of the discussion which takes place in the trial court also. Trial court also cannot, my lord, nobody can argue before the trial court outside the purview of what has fallen from your lordship. Now, my lord, if it is found or if it is held by the trial court, notwithstanding this submission, that Section 34 provisions have been contravened, nonetheless, the trial court does not agree with that. We come before the Honorable Court of Appeal for the purpose of questioning the judgment of the trial court. That look, this is the provision, this is the argument which was made by us, which is in contravention of Section 34. Therefore, the learned judge went wrong in not accepting my submission. That is the submission I make before your lordship in a court of appeal. So why should, my lord, I do not understand that, why should under Section 37, the power of the appellate court will be in any way restricted than what is contained, what is the power of the jurisdiction of the trial court when hearing a Section 34 application. Well, Section 37 is in clear terms. There is nothing, no restriction. Kindly see, it says appealable orders. Notwithstanding anything contained in any other law for the timing in force, an appeal shall lie from the following orders and from no other, to the court authorized by law to hear the appeals from the original decrees of the court passing the order, namely, A, refusing to refer the parties to arbitration, granting or refusing grant measure Section 9, setting aside or refusing to set aside an arbitral award under Section 34. I do not find any restriction in the appellate court's jurisdiction in, my lord, hearing an appeal. It is exactly hearing of an appeal as it is, my lord, happens in. Why should it, my lord, be? It is further restricted in the appellate court. I don't know. But anyway, be that as it may, but this is what the Supreme Court has said. I am bound by this observation. So I'll have to see in the facts of this case in what way the learned trial judge had gone wrong. So that is the exercise, my lord, I have got to undertake before lordship. Kindly, my lord, come to para 20 of this judgment of the Supreme Court. Thank you. Well, para 20. In view of the above position in law on the subject, the scope of the intervention of the court in arbitral matters is virtually prohibited, if not absolutely barred, and that the interference is confined only to the extent envisaged under Section 34 of the Act. Of course it is. It is not like an ordinary appeal. I'll have to show to your lordship that the learned judge, the trial judge, has, my lord, not gone in accordance with Section 34 of the Act. The appellate power under Section 37 of the Act is limited within the domain of Section 34. This is the correct point. It is limited within the domain of Section 34 of the Act. It is exercisable only to find out if the court exercising power under Section 34 of the Act has acted within its limits as prescribed thereunder, or has exceeded or failed to exercise the power so conferred. The appellate court has no authority of law to consider the matter in dispute before the arbitral tribunal or merits. These are all granted on merits, so as to find out as to whether the decision of the arbitral tribunal is right or wrong upon reappraisal of evidence. Well, the limitation is upon reappraisal of evidence, as if it is sitting in an ordinary court of appeal. If it is only where the court exercising power under Section 34 has failed to exercise the jurisdiction vested in it by Section 34, or has traveled beyond its jurisdiction, that the appellate court can step in and set aside the order passed under Section 34 of the Act. Its power is more akin to that of superintendents, as is vested in civil courts while exercising revisionary power. The arbitral award is not liable to be interfered unless a case for interference as set out in the earlier part of the decision is made out. Now, my lord, earlier part of the decision, I take it, my lord, Ahuja, I take it associate engineering, everything. So, my lord, in the earlier part is made out. It cannot be disturbed only for the reasons. Therefore, my lord, I'll have to show to your lordship the trial court judgment and why I am aggrieved. My lord, now keeping this in my lord, I'm sorry, my lord, my preliminary submissions have taken your lordship into a sort of uncharted field of interpretation of statutes and interpretation of judgments. But my lord, I think it was necessary because, my lord, this is what the Supreme Court has said. I will have to confine myself to this. My lord, keeping this in mind, I will request your lordship to look into the trial court judgment. I think I'll have to start from. No, actually. My lord, the trial court judgment, your lordship will is to find in volume 43. Page 6318, volume 43 ta din.
We'll read it from the memorandum of appeal.
Memorandum is very well.
So kindly refer to the internal page numbers of the judgment.
Yes.
That will match.
I will not trouble your lordship with any other finding with regard to the wrongful termination, with regard to other, because all factual things. I shall confine myself to that part of the judgment which, my lord, concerns, my lord, perversity, basically. Lordship will please to come to page.
Both parties had challenged the award.
My lord.
Hmm?
The respondent has challenged the award. My lord, if I may just give your lordship the background to it to some extent. My lord, this is with regard to a gas sale and purchase agreement that this dispute arose between the parties. I'm just refreshing your lordship's memory. And my lord, this particular agreement contained various provisions. My lord, clause 5, if your lordship takes the agreement, that your lordship will, I think, my lord, there's a separate volume of book given. My lord, copy of the, well, this will be easier for your lordship to handle. A gas sale agreement, in the index, my lord, gas sale agreement and award. These are there. So your lordship can look into that. Has your lordship, my lord, got this kind of a volume, which has got only 2 documents? A page in judge. Kindly come to page 2 of this, the gas sale agreement. Whereas the buyer desires to purchase and receive CBM gas for use as hereinafter referred to as the gas from the seller. The seller is my learned friend's client, buyer is my client. And seller agrees to sell and deliver to the buyer CBM gas as supplied to the seller on the terms and conditions stated hereunder, which have been mutually agreed to between the seller and the buyer. Now, my lord, here I will request your lordship to come to page 3 of that. Clause 2, period of the contract. This contract shall come into force from the date it is signed. The seller will use its best endeavor to lay down the pipeline to the buyer's premises within 45 days post signing of the agreement and submission of the bank guarantee and clearance of ROUs from the statutory authority, thus enabling the seller to commence the work for the supply from the day all requisite permissions are received as applicable and usage of CBM and at buyer's system. During the course, the buyer shall install all facilities to commission CBM gas. This contract, and this is the important clause, shall remain in force till 25 years, subject to the revision of terms and conditions, including price, as mentioned in clause 10.1. The seller reserves its right to review and may revise the terms and conditions contained herein, including the price of the gas, after expiry of the fixed period as defined in clause 10.2. So, my lord, this is for 25 years from the date of 11th May 2011, that is up to, my lord, 2034, it was to remain in force. Then, my lord, kindly come to clause 4. Clause 5, quantity of gas. Only I am, my lord, adverting to the important clauses of this agreement. Subject always to the availability of gas and seller's ability to supply the same to the buyer, the seller agrees to sell the gas on firm basis to the buyer, to be used by the buyer as fuel solely for its own business purposes, subject to the maximum of 35,000 standard cubic meters SCM per day, and total monthly 9,10,000 SCM standard cubic meters per month, working days in a month, hereinafter called the contracted quantity. There was a breach of this, and therefore, my lord, the agreement was terminated. This is clause 5. Then, my lord, kindly come to there is one clause that I would like to show to you. 5.2. Now 5.2 er aage. Just before 5.2, my lord, the last sentence on the next page top. In case the period of reduction of supply or stoppage in supply from the seller side lasts to continuous period of more than 3 months, then either party, buyer or seller, shall be free to terminate the contract by a written notice, etc. Then, my lord, 5.2. Subject to clauses 8.3 and 9, in case the seller is ready and able to supply the contracted quantity of gas, but buyer purchases gas less than K%, K% has been defined in the, then the buyer shall have to pay to the seller for his quarterly minimum guaranteed quantity, hereinafter referred to as the minimum guaranteed offtake, that is MGO, of K% of the contracted quantity. The MGO will be applicable after 45 days from the commencement of the supply of CBM gas, will be known as reading period. At the end of the reading period, buyer may amend etc. the contracted quantity based upon actual consumption of CBM. Then, my lord, the formula has been given. MGO is equal to, this minimum guaranteed offtake is equal to daily contracted quantity, which is 3,50,000, your lordship has been pleased to see, into the number of days in a quarter, that is, my lord, 75 days, into K, that is 80%. K is 80%. So, my lord, this is the minimum guaranteed quantity, 35,000 into 75 into 80%. This is the formula. My lord, I am not going to trouble your lordship with this, my lord, at all. This is what, and my lord, the allegation was that we failed to do that. The twofold allegations, my lord, which had come into, had been taken note of by the learned arbitrator, and I am not going to question either of them. First is, I failed to take this minimum guaranteed offtake per month, and number 2 is, I failed to, my lord, furnish the bank guarantee. There are 2 bank guarantees furnished by me. First bank guarantee for rupees, my lord, 1 crore and odd, that I renewed, revolving bank guarantee. But the second bank guarantee, I did not renew. So, my lord, that is the second point which has been taken note of. I am not troubling your lordship with this. Minimum guarantee offtake, I have shown your lordship. Then force majeure clause, billing payment, I am not troubling. Seeker, kindly come to page 10 of this, 11.5. This is, my lord, where we have defaulted. The buyer shall submit a revolving confirmed bank guarantee, which will always remain in place for the amount of the contracted quantity for 1 month. In case of default in payment, the seller shall have the right to encash in part or full the bank guarantee to recover all its dues at any point of time. In case there is shortfall, the buyer will have to pay the same to the seller immediately on demand. Format of the BG is attached. My lord, in terms of this, the first BG, the first bank guarantee was, my lord, for 1,75,80,472. I'm not troubling your lordship with, my lord, where it is. And the second bank guarantee was for rupees 93,18,000 and odd. So this first bank guarantee I kept on renewing. Second bank guarantee I did not. So this is one of the points the arbitrators have taken note of and said that therefore the termination of the contract is justified. So, my lord, I am not troubling your lordship with this. This is, my lord, the agreement. Now, my lord, keeping this in mind, if your lordship now come to the impugned judgment, because this is the judgment on the basis of Supreme Court decision, my lord, I will have to assail before your lordship. Otherwise, I don't succeed. My lord, kindly come to page. Your lordship has got. আছে দেখি এটা আমার মধ্যে নেই বোধহয় আছে হ্যাঁ yes my lord it is there but আমারটা আবার মার্ক করা রয়েছে my lord in this compilation itself my lord junior has rightly pointed out I have looked into from the আমার এখানে জাজমেন্টটা নেই your lordship looks into my lord the memorandum of appeal there your lordship will please to see I request your lordship to come straight to I am not going to trouble your lordship with anything else because I cannot reopen the issue I will not try to reopen the issue. আমি সেখানে আসবো তার আগে আমি দেখছি যে কোনো জাজমেন্টে কোনো ইয়ে আছে কিনা My lord, the arguments have been recorded here. I'm not going to trouble your lordship with that. Kindly come to paragraph 15. Paragraph 15 is learned senior counsel next argues the earlier part I am giving a go by. The learned senior counsel next argues the award of rupees 58 crores 50 lakhs 45,169 as damages for breach of MGO clause. This was done on the basis of up to 2034. How much will be consumed? What is the value? 15% of that has been calculated on, and my lord, this award has been given. Learned senior counsel next argues that the award of rupees 58 crores 50 lakhs as damages for breach of MGO clause from July 2014 is expressly perverse and vitiated by patent illegality. This your lordship will please to find at para 15. This was the argument which was made, being based on no evidence of any loss or damage suffered by the claimant. Your lordship has got that. Yes. Then, my lord, para 16. The award it is submitted fails to advert to relevant materials and evidence produced by the petitioner, which in fact established that the claimant was able to sell and allot the gas meant for the petitioner to third parties and thus suffered no loss or damage. This is a very important point which was argued. Section 73 and 74 of the Contract Act, I shall refer your lordship to. What was argued by my lord, Mr. S.P. Chinoy, who appeared before the trial court, his argument was that, look, this particular, you are claiming an award for 25 years of gas supply. But if it is shown that the minimum guaranteed offtake, which I am to take, I could not take or I did not take, that amount of gas has been supplied to third parties, then you did not suffer any loss. The concept of mitigation of damage was completely ignored, both by the my lord, the arbitral tribunal and also by my lord. My lord, that is my submission. This is the bone of my submission. This is the crux of the matter that I am going to urge for lordship. And this is what was argued in paragraph.
Order it filed to the. Just one second, Mr. Mitra.
না করেছি আমার মনে আছে
Yes. All right.
So, my lord, this point had been taken before the learned trial judge, paragraph 1516. Then, my lord, the tribunal proceeded on the premise that the recording in paragraph 41 of the CCI judgment in a proceeding initiated by an employee associate of the petitioner before CCI, impugning the various clauses of the gas purchase agreement to the effect that the claimant respondent had to flare up 28.48% of the gas produced in 2025, 2026, 2015, 2016, as it had no market for the same in the face of the competing products. The impugned award holds that these findings of the fact were affirmed by the High Court at Delhi. This is something, my lord, which I should take. Well, therefore, here, what the contention was that the flaring up of 28.48% is not a correct thing. You have relied, the arbitrators have gone on to that on the basis of that. If I can show that it is not so, then the very foundation of the finding of the arbitral tribunal falls to the ground. The perversity will be there.
Will that not be reappraising the evidence?
I will submit to your lordship, no, it will not. It is not. If I can show to your lordship what has been taken as evidence is not evidence at all. There was no evidence, then perversity, question of perversity comes in. That is the way I look into it. It is not appraisal of evidence, whether it is right or wrong. It is, my lord, relying upon evidence.
So it is not the sufficiency of the quality or quantity of
Yes,
evidence,
quite right.
but that there was no evidence.
No evidence at all. That was wise. Then, my lord, it is argued by the petitioner that paragraph 41 of the CCI observation did not refer to any loss or damage caused to the claimant by the alleged breach of MGO clause, but was merely a general observation. Thus, such findings were not conclusive with the contemplation of section 61 of the Competition Act. Well, this, I shall just explain to your lordship what it meant. What was submitted was this: before the Competition Commission, a complaint was made by an employee of the appellant before your lordship, that this is a one-sided agreement. it was in contravention of the Competition Act, because the person who had entered into the agreement had a complete control, domination over the other party, and therefore this agreement, he challenged, my lord, the agreement itself, and that failed. I shall show to your lordship Competition Commission, the Competition Act. What is the scope of Competition Act? There, my lord, the finding as to how much is gas is flared and what is the damage suffered is not the issue at all. And Section 61 of the Competition Act, which has been adverted to here, is, my lord, confining the jurisdiction of the competition court, or rather tribunal, within the confines of that finding. It is not going into the merits of the controversy. The issue is, was the respondent in a dominant position to influence this particular agreement to make it a one-sided agreement, which is in contravention of the provisions of the Competition Act? That was the issue. So, my lord, the competition court or tribunal, or my lord, Delhi High Court, which it went into this matter, could not have gone into the issue of flaring up at all. And unfortunately, the learned tribunal and also, my lord, the learned trial judge had heavily relied upon this flaring up thing. Because if there had been no flaring up, no damage suffered, then you can't claim damage. And it is the incumbent upon a person who is claiming damage to come before the court and show, when that issue has been raised, that I suffer damage by reason of your non-compliance of MGO clause. This is absolutely incumbent. You can't just say that for 25 years you have to continue 35,000 cubic meter per month or per day or whatever it is. I calculate by multiplying, and then 15% of that, and I give an award. It is not so easy as all that. I am not questioning, I am questioning the jurisdiction of the arbitrator not to take note of the issue of mitigation of damage at all. And that is what Section 73 and 74 says. Then, my lord, kindly come to paragraph 20. Since the seller, the respondent, even after termination of the contract, was able to sell the contracted goods to third parties, there could not have been any loss or damage suffered by them. This is the point which was argued. Then the award relies on the judgment of Delhi High Court, dated October 10, 2019, which itself holds that the quantity of gas which was earlier supplied by the claimant to SRMB was, after termination of the contract, being supplied by the claimant to other purchasers. The Delhi High Court has held there is nothing to stop the manufacturer of gas to sell it to outsiders if it cannot sell it to X. The Delhi High Court has held, and on that his reliance had been placed. The Delhi High Court records that it is nobody's case that gas could not be supplied to other consumers, and that the fact that the quantity of gas which was earlier supplied to SRMB was, after termination of the contract, being supplied to other purchaser does not in any manner render clause 5.2a of the agreement unfair or discriminatory. That was the issue before them. The issue was that, therefore, reliance could not have been placed on this particular finding for the purpose of, my lord, going into the issue of mitigation of damage. Then, my lord, it has been submitted that thus the award is also perverse on such count, being contrary to the findings of the Delhi High Court. The documents produced by the petitioner, also which shows the flaring of gas after termination of the contract, was not considered by the tribunal. Further, it is argued by the petitioner SRMB that the tribunal declined to refer to the material evidence on such count, on the premise that SRMB had neither referred nor disclosed these materials. My lord, this is wholly wrong. This is wholly wrong because, my lord, extensive evidence was laid for the purpose of showing how, my lord, the gas, after the termination of the contract with me, how it has been sold to outsiders. And my lord, my client relied upon, before the learned tribunal, on evidence of third parties, not my evidence, of TRICIL, and my lord, there are independent. On the basis of that, unfortunately, the tribunal said, I will not look into the evidence because they have not pleaded it. Refuse to look into the evidence because you have not pleaded it. Well, I do not know. At least in Calcutta, we do not plead the evidence. But I have pleaded my ground. My ground is there. I shall go into that. I shall take your lordship into that. I raised an issue on that. Unfortunately, issues were not framed by the tribunal. I personally feel, having, my lord, handled so many cases, my lord, so many civil disputes in my life, the framing of the issues is one of the basic things which, my lord, guide the learned judge, into the correct track. But here the issues were not framed. And since the issues were not framed, when I led the evidence, the tribunal completely ignored the evidence. They said, I will not look into it because you have not pleaded it. I do not know. I pleaded. I shall show to your lordship what I pleaded. An issue would have been raised on that pleading. This is the only point I am going to urge before lordship. I stand or fall by that. I am not going to take your lordship into anything else. I say that what was necessary for the tribunal had not done it. When it was pointed out to the learned trial judge that this is what has happened, the learned trial judge ignored it. That is why I am before your lordship. I could have understood that you considered it and rejected. Then I couldn't have come before your lordship. This has not completely been ignored. It has not been looked into. And volumes of evidence has been laid on this. Kindly, my lord, come to paragraph 24. I say that issue would be raised on this itself. Kindly see, my lord, the judgment, paragraph 24. However, in the statement of defense, the petitioner denied the averment in SOC, that is statement of claim, that any loss or damage had been suffered in respect of MGO, or any amount was payable as quantified at the MGO from 2014 to 2034. The aforesaid pleading in statement of defense enabled the petitioner SRMB to produce evidence in the form of return filed by the claimant before the Directorate General of Hydrocarbon to show that no loss or damage had been suffered by the claimant post termination of the agreement dated in July 2014. So this has been recorded with the learned judge. And my lord, your lordship will see how he has dealt with it. With the greatest of respect to the learned trial judge. The tribunal completely ignored the evidence. This is the argument made, Mr. Aspichina. The tribunal completely ignored the evidence adduced by the petitioner, particularly the reports authored by CRICIL and CARE, being credit rating agencies engaged by the claimant to show that the claimant's customers and business had improved considerably post determination of the contract. My lord, these were, my lord, the claimant, my lord, produced this, and my lord, this was not taken note of. I relied upon that. Then, my lord, I will not trouble your lordship with this. Kindly, my lord, now come to. So I am just referring to this paragraph for showing that these arguments were made. Let us see, my lord, how the learned judge has dealt with this. Kindly come to paragraph 80. The others are, my lord, with regard to damage, with regard to the breach of contract, on which, my lord, finding has been made. I am not going to trouble your lordship with this because I cannot, my lord, reopen the issue, as the Supreme Courts have said repeatedly. My lord, kindly come to paragraph 80. That should be at page. Yes. Yes, internal page 24. The last component of argument of SRMB petitioner is that there was no evidence of loss to justify the award of damages. This is now the finding of the learned judge. However, the tribunal categorically relied on the order passed by CCI, the conclusion of which was ultimately affirmed on merit by the Delhi High Court, where it was observed that the claimant had to flare up 28.48% of the gas produced in 2015-16. That is, after illegal termination of the agreement by SRMB. Then para 82. The Delhi High Court, in somewhat different context, held, well, kindly note the word, somewhat different context, held that it was nobody's case that the gas could not be supplied to other consumers. In such backdrop, it was observed that it was not the case of SRMB that if customers are available requiring gas at a particular point of time, gas available to the claimants would not be supplied to them. The MGO liability, it was held, was only to mitigate the risk. My lord, kindly note the word, only to mitigate the risk in committing to a long-term supply, and that the fact that the quantity of gas which was earlier supplied was, after termination of the contract, being supplied to other purchasers does not in any manner render clause 5.2 of the agreement unfair or discriminatory. That was the issue. My lord, the Competition Commission has held, the Delhi High Court had confirmed that this clause 5.2 is neither unfair nor discriminatory. But it does not say anything about the damage suffered. It's a completely different, I should say, my lord, adjudication in a completely different field. Hence, then, my lord, kindly see the, I am questioning this. Hence, it is not a conclusive finding, nor was the court so called upon to decide on merits on the issue as to whether gas earlier supplied to SRMB was being supplied to others. The premise of paragraph 53 of the Delhi High Court judgment was merely that it was nobody's case that the gas could not be supplied to other. And even if there was such supply after termination of these contracts, it does not render clause 5.2 unfair or discriminatory. Nobody is questioning that. I am not saying, my lord, before your lordship, that this is unfair or discriminatory. I am saying that kindly find out as to whether the gas was supplied to others. If the gas was supplied to others, you are obliged to mitigate the loss. You are obliged to mitigate the loss. I just want to draw your lordship's attention to, I have got no whole, just stopping here for a moment, and my lord, giving your lordship this. Can you give me 1 second? Let's see how Chitian contract has said on this. Lordship will be, mine is an old edition, 25th edition. I could not afford the subsequent editions. I'm sure my learned friend has. I will just draw your lordship's attention, stopping here for a moment for the time being. Only one paragraph I rely upon now. I shall come to the other paragraphs afterwards. This is mitigation. Sorry, I mean, copy. I mean, আমার তো পুরনো এডিশন তুমি নেবে This 25th edition, my lord, is 1983, quite, but I think the law is the same now. Mitigation of damages. There are 3 rules often referred to under the comprehensive heading of mitigation. They will be considered in turn. First, the plaintiff cannot recover for loss consequent upon the defendant's breach of contract, where the plaintiff could have avoided the loss by taking reasonable steps. Secondly, if the plaintiff in fact avoids or mitigates his loss consequent upon the defendant's breach, he cannot recover for such avoided loss, even though the steps he took were more than could be reasonably required of him under the first rule. Thirdly, where the plaintiff incurs loss or expenses by taking reasonable steps to mitigate the loss resulting from the defendant's breach, the plaintiff may recover this further loss or expense from the defendant. But mitigation he will have to do. And this, my lord, what has been said here is our section 73 and 74 of the Contract Act. I shall show to you, lordship. I shall come to it, my lord, when I come to the question of law. I stopped here for the moment for the purpose of showing this. I said that this finding of the learned judge at page 25 was completely contrary to, my lord, the law on the subject. It says, my lord, the middle of paragraph 83, the said observations cannot be blown out of proportion, but has to be read in its context. Rather, it was the categorical finding of CCI order, which was affirmed by Delhi High Court on merits, that there was 28.48% flare-up of the gas produced subsequent to the termination of the contract, which was a specific and precisely enumerated value of such flare-up. I am questioning this. I say there is no finding of the tribunal. There is no finding of the Delhi High Court. This finding of 28.48 is a wholly, my lord, misconceived. Shall I show your lordship immediately now? Kindly, my lord, look into this judgment order of the CCI. First, see, my lord, the CCI, and then this your lordship will be pleased to find. CCI order is 16 February 2017. এটা বার করে দাও আমার কোথায় আছে? My lord will be pleased to come to. I go straight to my point. My lord, as this CCI order, your lordship will be pleased to. We have filed the notes of argument. এই পাঞ্চটা আছে ওখানে? দেওয়া আছে? Just এটা দিয়েছে? Just as a matter of interest, your lordship sees my notes of argument. It has been annexed. This was before the court, and the court considered this. Tribunal considered this. Court considered this. And reliance was placed upon one paragraph only. My lord, kindly come to page 101 of that. Sorry. 101 of this notes of argument. Your lordship will be pleased to find from page 88, the Competition Commission of India starts. Your lordship sees that. Kindly come to page 101. Quickly, I am taking your lordship. Without prejudice to GCL's position, para 36, that the relevant market is wider, it was argued on its behalf that there are several defects in the DG's analysis of dominance, even in the my lord, kindly note, it is a question of dominance. That was what was before the Competition Commission. In this regard, para 37, in this regard, it was submitted by GECL, that is the respondent before your lordship, that DG failed, etc. I am not troubling your lordship. Kindly come to para 38. Specifically, OP has referred to the negotiation. The reason why I am drawing your lordship's attention is these paragraphs, my lord, recording the submission made on behalf of the respondent. The first sentence starts that it was submitted by GECL. Similarly, paragraph 38, specifically, OP has referred to the negotiation held. Then, my lord, para 39, it was further contended that SRMB, these are all arguments. Then, my lord, kindly come to para 39 gone, then para 40. Criticism was also made by GECL of DG's excessively relying upon the market share. Well, this particular DG's report came in for challenge before the Competition Commission. That is what has been referred to. Therefore, criticism was also made by GECL. Then kindly come to paragraph 41. Lastly, on the issue of dominance, it is very important, very, very important. On the issue of dominance, it was submitted, kindly note this submission, that GECL has no financial strength. DG has relied upon financials as reported in annual reports of GECL's financial strength. Mere profitability on the books of accounts cannot lead to an inference of dominance. This is the submission. A more accurate measure is the net cash generation, which has been negative till date of GECL. This shows that GECL is still in the process of recovering its initial capital investment. Further, GECL has had to flare up 28 point. This is the only. So this is the submission which was made on behalf of GCL, that GCL had to flare up 28.48%. And this has been taken as the finding of the Competition Commission of India. And this was, my lord, said to have been confirmed with the Delhi High Court. I said, this is the perversity. And this goes to the root of the matter. You went on the basis of this flaring up when there was no flaring up. This is the submission made. Then kindly, my lord, this will be clear from the next paragraph. The Commission has carefully considered the submissions made on behalf of OP on the issue of dominance. And then, my lord, the order has been passed. So, my lord, my first submission is this. The perversity is writ large on the award, on the judgment of the learned trial judge. That is why I am before your lordship. What has been, my lord, submission of the party had been taken as an evidence, confirmed by the Delhi High Court. And this is what was urged before the learned trial judge. Apparently, unfortunately, my lord, it didn't find any find favor with the learned trial judge. So I am questioning it before your lordship. And this is the basis on which the damage has been awarded.
5 minutes.
Lordship. So, my lord, I am submitting to your lordship, this is not appraisal of evidence. This is relying upon evidence which was no evidence. That is why it is purpose.
Mr. Mitra, only for the benefit of your learned friends. Shall we continue till recess? Then we can release.
I'm told at 12:30 your lordship has got a matter fixed.
Oh, yes, yes. So, correct. So from 12:30, the other matter.
And then from 2 o'clock, there's the third matter.
Oh, yes. That shouldn't take long. That shouldn't take long.
And depending upon, my lord, the appellant who is facing the firing squad. I
Very
don't know how long, my lord, he will be able to pull through.
Very well.
The senior has not been well, so should not
Thank
stress
you.
it.
Yeah.
You're not well?
So, my lord, the weekend, what should I say? Weekend things, my lord, that happened. So, yesterday morning, I was very the doctors came and suggested me to be removed to the hospital. I said, don't do anything of the sort.
No, whenever you want to.
No, I am all right. My learned friend is very kind. Well, I think I will be able to. There's no problem. Since I'm on this, my lord, I will be able to. There is no. My lord, kindly come to paragraph. I have shown to your lordship, my lord, page 25, paragraph 83, last sentence. The said observation cannot be blown out of proportion, but has to be read in its context. Rather, it was categorical finding of the CCI order, which was affirmed by the Delhi High Court on merits, that there was 28.48% flare-up of the gas produced subsequent to the termination of the contract, which was a specific and precisely enumerated value of such flare-up. I said, this is wholly wrong. Even otherwise, if we proceed on the basis of crisis report and care report, as well as the documents filed by SRMB, which if assumed to go on to show that there was almost equivalent flare-up of gas even after termination of the contract as there was before, the same does not help SRMB in any manner. Or I could not follow what. But my lord, this crisis report, care report had not been taken note of, not considered by the learned tribunal. And I shall show to your lordship how it has been dealt with. Then, my lord, kindly come to page 26. The premise of the MGO clause is not an actual occasion of loss suffered by the supplier. It is a prevalent practice in such long-term contracts for supply of energy by way of electricity, gas, etc., to introduce minimum consumption clause, which is in the nature of an assurance to the supplier that huge investment in grid and other infrastructure for supply to consumers, which is undertaken by such supplier, is justified by long-term supply. Premature termination would not only entail loss of the minimum guaranteed amount, which is the MGO value in the present case, but also may be detrimental to the maintenance of the supply grid itself. I pause here for a moment. My lord, I submit to your lordship, this is wholly contrary to section 74. 74 of the Contract Act, which I shall presently draw your lordship's attention to, is this very issue. Minimum guaranteed mean this is the minimum that you are to take supply of. But on termination of the contract, you are to show that the damage you have suffered is as per up to the minimum guaranteed supply, in other minimum guaranteed offtake. In other words, that is the ceiling up to which you can claim damage. But if you do not prove damage, you are not entitled to claim anything. You cannot say that there is this minimum guaranteed offtake clause. Therefore, I am going to take it from you, whether I suffer damage or not. This completely, my lord, ignores and, my lord, makes oblivious the entire concept of mitigation of damage. You mitigate your damage, but you are not entitled to claim damage more than the MGO clause. but you will have to first prove that there is a damage. If you don't prove damage, you don't get the minimum guarantee of taking. That was our submission. Then, my lord, premature termination would not, last sentence of paragraph 85, premature termination would not only entail loss to the minimum guaranteed amount, which is the MGO value of the present case, but also may be detrimental to the maintenance of the supply grid itself. My lord, in this connection, immediately, my lord, if I may just refer your lordship to section 73 and 74 of the Contract Act. My lord, if this is correct, my lord, this is then I have not understood, my lord, the concept of section 73 and 74 myself of the Contract Act, even though I have dealt with it, my lord, for all these years. তোমার কাছে Contract Act আছে? হ্যাঁ, দাও না। My lord, may I hand up to your lordship? Sure. আরেকটা কপি এনে দিই?
Yes.
Lordship has got it. My lord, kindly come to section 73. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. Then, my lord, I am not troubling your lordship the next rest of the section. Kindly come to section 74. Compensation for breach of contract where penalty is stipulated for. When a contract has been broken, if a sum is named in the contract as the amount to be paid, the same is here, section 74. When a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation, not exceeding the amount so named, or as the case may be, the penalty stipulated for. This has been interpreted by the courts here, courts over there, overseas, my lord. It has been interpreted. Contract reasonable compensation not exceeding the amount, meaning thereby, this, my lord, inheres in it, this concept inheres in it, my lord, the concept of mitigation of damage. This is what, my lord, the treaty on contract has said. You must show that you have now suffered damage. Nowadays, my lord, the very recent Supreme Court judgments has very clearly has said so, that you just cannot throw this word damage into the air and claim damage. You will have to prove that you have suffered. You are entitled to claim under section 74 the maximum of that amount, which has been mentioned. Mitigation. But you will have to show that this is a reasonable compensation.
Mr. Mitra, as my brother points out, explanation under section 73, that really talks of mitigation. If you
Yes.
come to it.
My lord, Exactly. Indirect loss and damage sustained.
No. Explanation. You see, after section 73,
Yes.
compensation for failure, then explanation.
In estimating the loss or damage arising from breach of contract, the means which existed for remedying the convenience, I am grateful to your lordship, remedying the inconvenience caused by or non-performance of the contract must be taken into account. I don't know why I forgot to mention this, because this is exactly what the Supreme Court has said. Supreme Court has exactly said this. My lord, I come back to the judgment and then, my lord, Para 86. Also, it is irrelevant whether the same amount of gas was as consumed before by SRMB was flared up, even after termination of the contract with SRMB. As long as there was even a small amount of flare up, it would indicate that at least some of the gas produced by supplier is not used up. It is not a relevant question whether the gas earmarked for the consumer SRMB was being supplied to some other consumer, since supply to one consumer is not mutually exclusive to the supply of the other. Well, I think this is a completely wrong, with the greatest of respect to the learned judge, my lord, this is a completely wrong, my lord, what should I say, my lord, appreciation of the law on the subject. My lord, he cannot say that it's not relevant question. This is the relevant question. How can it be said it's not relevant question with the gas earmarked for the consumer SRMB was being supplied to some other consumer? This is the precisely mitigation. This is precisely mitigation. And this is where the learned judge went wrong. It may very well be that the supplier enhances the infrastructure or on the basis of the same infrastructure caters to more consumers, thereby increasing its earnings. If it increases its earnings, then no damage is being suffered. And this comes with the explanation of section 73. Even if SRMB was continued to be supplied with gas, it was open to the claimant supplier to increase its supply and or to maintain its previous supply and go on supplying gas from its network grid to other new consumers, which would fetch more profit to the supplier. There was no exclusivity clause in the agreement between the parties restricting the supply. My lord, with the greatest of respect to the learned trial judge, I think, my lord, his lordship has failed to, my lord, appreciate the submission made that it is not a question of whether there was an exclusionary clause or not. There might not have been exclusionary clause. And that would have entitled the party concerned to supply to third parties. But once you supply to the third parties, you are entitled to give me credit for that. So that the damage which you are claiming for 25 years up to 2034 immediately comes down. Then, my lord, 87, thus, as long as there is even a wee bit of flare up of gases, there is wastage of gas produced by the supplier, and consequently consequentially, there cannot be any dilution of MGO loss suffered by the supplier. Theoretically, after the termination, a supplier might have started supply to new consumers. Even then, as long as the entire amount of produced gas was not exhausted, the supplier would continue to suffer loss due to termination of the contract for the particular amount of gas which was to be supplied to SRMB. It is not that the gas earmarked for SRMB is being supplied to others. The claimant is a producer of gas and can very well supply to many other consumers than SRMB. This proves my point.
Mr. Banerjee, just please note from where is the learned judge getting these things? Just note that.
Flaring up.
All these observations here.
No, this is the logic which the learned judge used, saying that just because, my lord, I make more profit doesn't mean, my lord, I don't suffer the loss.
Very well, flaring up.
Is CCI order?
CCI order records your client's submission.
Paragraph 87, 67. Paragraph 67. That was, my lord, very strongly argued, my lord, before the arbitration as well as
Paragraph 67.
Yes.
Paragraph 67. Let us see.
There are 34 years contract. Page 1 para 60, sir. No, 24 years. 2030.
Your Lordship kindly comes to para 67. Let me place it. On a careful consideration of the matter, it may be observed that production of CBM gas production is a continuous process that starts once a well is dug and stops only when the well goes dry. GECL plans its production based on contracted quantity agreed with its customers on a long-term basis. Once the CBM is produced, it cannot be stored, and if the customer fails to offtake the contracted quantity, GECL has no option but to flare up the gas. There is no spot market for CBM gas, where GECL can sell the gas which is not consumed by the customer. MGO liability is a standard clause across most long-term supply contracts of producers and is intended to cover the risk of the seller in committing to sell a fixed quantity on a long-term basis and to assure the buyer of a firm supply of the gas. Correspondingly, GECL is liable for differential fuel cost under SRMB agreement if its supply falls below the MGO level, and therefore the clause is equitable. The DG's reasoning suffers from a flaw, as in the gas control contracts of other gas suppliers. Upstream suppliers who impose MGO liability are producers themselves. There is no question of discrimination. Kindly note, discrimination. If one considers that GECL contractor negotiated with each individual customer and the SRMB did not raise the issue regarding MGO liability at the time of GSPA. It is only after SRMB has signed an agreement with SR, it requested for waiver of MGO liability. GECL was willing to accept, but subject to reasonable revision of price. The informant's argument regarding GECL not incurring any financial liability for the gas which is flared is flawed, as royalty payable to the government is only one component of the cost involved. There are other production costs to be recovered in case the gas is flared up. Further, GECL cannot divert gas which is not consumed by one customer to another customer, as this would depend upon the requirements of other customers. In case the stoppage of supply, both GECL, where do I find this?
Sorry, this we had an MGO clause with Mr. Mitra's client, which ensured knows MGO clauses that I would have got my minimum guaranteed offtake without even if we didn't take any supply. I asked for 24, quite naturally asked for the entire period. I was given by the arbitrator for a percentage of it, saying that you can't get it.
We'll hear you.
And these all findings are there.
So, my lord, my submission remains that this reliance upon this 41 points, this 28 point something, as per the para 41 of this, this is not really, my lord, finding of the CCA. It is not a finding of the CCA at all. The submission of GECL has been, my lord, taken as a gospel truth that had gone into the, my lord, the tribunal's order, and that had gone into the learned trial judge's order. My lord, surprisingly, there is not a whisper, and I say that without any fear of contradiction, by a learned friend or anybody else, in the judgment of the Delhi High Court which confirmed this order, not a whisper with regard to 28.48%. Where did the learned trial judge get this from? That it was confirmed, this 28.48% was confirmed, and on the basis of that, you have awarded damage, and damage up to the extent of huge crores of rupees, when you are merely going on supplying to others. Third-party report says so. I shall place it before your lordship, and I shall show to your lordship. These documents had not been taken note of by the trial court, by the learned tribunal. This is, my lord, I submit to your lordship, my lord, this is perversity. I am using this strong language. Perversity writ large. You are relying upon as a piece of evidence on a submission of one of the parties to the proceedings. If that is not perversity, what is perversity? And on the basis of that, you are awarding damage. My lord, kindly come to page 27. After para 87, para 88, hence the argument of SRMB linking the quantum of post-termination flare-up of gases to absence of loss is irrational and not acceptable. Even if the flare-up remains the same, the supplier suffers loss to the extent of the MGO amount as long as there is flare-up of any amount. This is wrong. This is wholly wrong. If, my lord, instead of 28.87%, if the flaring up is 2%, then you take the entire amount of damage. This is where I say that the learned judge has gone wrong. Then, my lord, it has gone on. Well, I think what happened was this. The learned judge was more impressed by the fact that in electricity contracts also, there is MGO. Electricity contract, it is supplying to a particular person. So, my lord, there is some relevance of MGO clause. Here, my lord, you are not supplying to one person. You can supply if you are earmarked for one person supply, then if that particular person does not take the supply, you can go on supplying to others. Nothing to stop you from doing so. And these reports are saying that you are doing so. My submission is this. Ultimately, what is the quantum, the court will decide. I say that I am questioning the entire situation in which, my lord, these evidence has been ignored. This is where the perversity comes in. You are saying, I will not take note of all this evidence. Why? Because 28.5, this is, my lord, this is the gospel truth. And on the basis of that, I shall give. And, my lord, the court has also recorded, even if a small infinitesimal portion is being flared up, then even then, my lord, that damage can be claimed. This is wrong, wholly wrong, entirely wrong. Then, my lord, kindly come to page, I shall stop it, my lord. There is a matter at 12:30. Kindly, my lord, I just place this and I stop it for the day. Page 28, paragraph 90. The concept of MGO in any event is to provide certainty to the supplier and to ensure that the grid infrastructure installed on the basis of long-term supply agreement is utilized to the full, which would justify the infrastructure and maintenance expenses of the supply of grid as well. It acts as a long-term insurance to cover the infrastructure and allied expenses and does not necessarily require proof of actual future loss as such. This is, my lord, my lord, I submit to your lordship, does not necessarily require proof of actual. This is contrary to section 74. You will have to prove it. And that is the maximum. If you can prove that 2% has been suffered, you are entitled to get 2%, not the MGO. This is where, my lord, the learned judge has gone wrong. The rudiments of such future loss are embedded in the MGO clause of the agreement itself, which has been wrongfully terminated by the present petitioner. Hence, as a comprehensive perusal of the impugned award, I am unable to find any infirmity or illegality in the same. In view of the above discussion, the petitioner's argument on perversity and patent illegality do not cut eyes at all. The learned counsel had relied upon the observations in, my lord, associated engineering case. Is exactly what it says, that therefore the arguments are perversity and patent illegality. Paragraph 40 and 41.
That holds for that. Isn't that quite contrary to the language of the statute?
Well, my point is short, and I am going to hammer on this point, nothing else. This is the only point I am going to add, Lordship. My lord, the only other thing is
Hammer on the point, not our heads. Or your learned friends.
I may hammer it on my learned friends' head, not your lordships.
So shall we stop today?
Your lordship. My lord, the only thing is this, my lord, interim order which was passed on the 20th June 2025, it was till the end of this month. This is the order of the law.
End of this month, July.
Yes, it looks like it.
Since we are hearing, Mr. Banerjee, এই কোথায় দাও order-টা?
Absolutely. Extended for a limited period under pressure.
Mr. Mitro, learned কে লিখছো? Mr. Mitro, learned senior counsel representing the appellant. আজকে তো শুরু করবি। Begins his argument afresh since this is a different bench.
Well, it's the same.
Oh, same bench, sorry.
Yes.
Resumes his argument.
Yes.
Resumes his
The
argument.
lucky moment.
But does not conclude. Paragraph lists the matter once again.
Usual course, I think.
Tomorrow, if it comes, I mean, let it be in the list. কালকে লিস্টেই থাকবে।
Wednesday, my lord, is no Wednesday.
See, tomorrow we'll take up appellate side first, but
Yes.
appellate side matters are far and few. So
We shall be in readiness.
there's a possibility.
No, it's okay. Just,
But Mr. Mitro, better be on Wednesday. You also take some rest. Yes,
it's all
take
right.
some rest.
Any particular, it will be called.
Should be called.
It's
But
topic
Wednesday,
That matter.
no, only thing Wednesday non-commercial will be first.
After that,
non-commercial has got a long list.
Then what we do, Mr. Banerjee, let us keep it on Friday, where again we'll take up commercial first. ঠিক বললাম তো? So let it be on Fridays. That's
আমার মনে হয় Wednesday থাক.
Wednesday.
We shall take a chance.
Very well.
Wednesday.
It's not Wednesday.
There is some.
Come up anyone
Yes.
Friday. We can. Perhaps follow this week.
আমার মনে হয়
Try and
Wednesday
finish the
date
matter.
Wednesday date paragraph. The interim order that is in operation
শুধু এই পয়েন্টের
stands extended till the end of August 2025, August, 2025, or until further order, whichever is earlier.
It's an interesting matter, Malak.
It is.
And my lord, I was hesitant because it was a high-powered tribunal.
Yes, so I saw.
Been there, Malak, right from the beginning. So, Malak, I am Malak.
I was not there at all. But then again, my lord, I was not in the trial court also.
Someone came from.
Did he actually come down or he argued?
Malak, he came.
He came.
We had the pleasure, Malak. We will recall Mr. Chinoy also, Malak. We have.
না না চুপ চুপ থামুন তো আপনি, থামুন না। একদম। আরে তুমি এসো আগে দাদা বাইরে আপনি
Well, this was that matter, the two MOU matter.
Yes. March and October, which year?
13.
2013.
And the litigation started 2023, exactly 10 years thereafter. March 13 to March 23 is a section 9, section 21. Last year, I remember showing Mr. mainly Justice Rai, because was not there earlier, the clauses of the March MOU and the clauses of the October MOU to show that the subject matter is not the same. March MOU, just briefly, has 55 lakh odd shares are being transferred. October MOU relates to 17 lakh of shares of MBL being transferred. March MOU considers release of personal guarantees by Group 1 for MBL and up, while October MOU is only for MBL. The March MOU has provision for transfer of another company, respondent number 3 to me, as well as all the associate companies, subsidiaries, associate companies like MSP, like MBLA, to my group. October MOU is silent. March MOU provides for resignation from their side, from the board of directors of my group of companies. October MOU is silent. March MOU contemplates a composite remuneration from our side, 28 point some crores, plus release of guarantees, while the March MOU relates to 17 lakh shares at 63 rupees per share. It's a single share transaction. It is not the case, not anybody's case, that by October MOU, out of the 55 lakh shares, 38 lakh shares had been transferred already by October MOU, so that the remaining were only 17 lakh shares, which could be superseded by the October MOU. That is not so. In fact, less than 1 lakh shares had been transferred before October MOU. And the balance 34 lakh odd shares, which have in fact been transferred, are all post October MOU by different individuals who are not parties to the October MOU, save and except one, Prabhu International, who has also transferred some block of shares. It is not their case that by the time October MOU came, the ARP guarantee was released. So what remained were the FBL guarantees. So October, by implication, superseded. In fact, the ARP guarantee was released last in 2021. And the MBL guarantees, 6 of them released before October, I think. 6 of them released before October, and 7 of them released after October, MBL. So if one goes behind the black and white and goes by logic also, October MOU could not have intended to supersede or novate the March MOU. It is not the case that, not the fact that they had already resigned from the board of directors from MBL, so it was not necessary for October MOU to have that. Because after all, I'm not transferring, I'm not acquiring all the shares and releasing their guarantee with them still remaining on the board. In fact, they all resigned post the October MOU. It is not the case that the other companies had already been transferred before October MOU. In fact, Prabhu, one of the, respondent number 3 is yet to be transferred. Others have been transferred all afterwards. This is the position. So logic, black and white, certainly cannot be a novation, because 2 out of the parties, out of the 7 parties, one from their side, who in the impugned judgment is referred to as admittedly not a party to the March MOU. So going by that logic, October can never be touched. But 7 out of the 7, 2 of them are parties to the October MOU. 7 parties to the first MOU. Black and white, subject matter is completely different, but logic applied also, it cannot be. Secondly, the first MOU contemplates, March MOU contemplates share transfer by transfers in 2 forms, by sale as well as by gift. which is also logically in sync with the lump sum consideration. 28.50 crores, because this is a quoted company, shares has to be transferred on the quoted price of the day, whenever it's transferred. So out of the, and in fact, only the first MOU contemplates gifts, and large block of shares have been gifted. 20 odd lakh shares out of 35 lakh shares have been gifted, all post the October MOU. So 24.95 crores paid, 35 lakh or 37 lakh shares or 38 lakh shares have been transferred, out of which around 23 lakhs by gifts, and rest all at quoted price. Total is mine. I have paid slightly more than what I have got. Not slightly, around 10% if you go by number of shares, more than what I have got. On the other hand, October MOU is not a single share transfer at 63 rupees. And it's also, going by their own case, it is an impossibility to transfer the shares at 63 rupees without there being any provision for gifts. Because it is their case, so is it a law that quoted company, it has to be, if there's a transfer, sale has to be on the quoted price. So there could not be, at a constant price, sale could never have happened, unless there is contemplated some underhand return of money or payment of money. That's nobody's case, that's not a fact, and that's can't be recognized. It's a virtual impossibility. 63 rupees should be transferred. And October MOU, according to us, has not been performed at all. They have not shown how October MOU has at all been performed. March MOU, according to me, with documents I have shown, has been performed, which they are trying to say that no, it was after July, it was not performed, it was all oral understanding. The far-fetched case that by two warring groups, by oral understanding, transferring shares by gifts, resigning from boards, releasing the guarantees, then there would not have been litigations from 2015 onwards. The first list. That's a fairly far-fetched submission, which even logically won't be accepted, and I don't think even the arbitrator will accept or the trial court will accept. So short of there being an oral understanding for each transaction and all out of good gesture, there has to be this March MOU which has been performed. And performed almost entirely beyond the cutoff date of 31st of July 2030. So the cutoff date was given a go-by, and we step into the arena of Article 54, second part. Not date fixed, but by parties by conduct make it yes. And the other part is that their case is totally of approbate, reprobate. In the suit, when I asked, not me, my company, it was my son's company, MBLA, asked for specific performance of the October MOU, they come and argue that this is a void contract. Securities Contract Regulation Act. Stamp Act. It's a void contract, this cannot be performed. This is the order records that. And now they turned around in 2023, filed an application without there being a counterclaim for enforcement of the remedy in my suit. And I made what wrong did I do? By withdrawing my suit. I should have let them keep the suit, not taken the point of limitation, not taken the point of no counterclaim, and allowed that application. Just because I had wanted a specific performance in the year 2015 or so when we filed the suit and 16. That I am not bound to be obliged to want the performance if the property disappears. And in fact, I have shown that the share prices had altogether changed. So that is, withdrawing my suit is another misconduct, which I don't find any misconduct. And anyway, that's the subject matter of the restitution application pending before another court. It'll all come to my lord's court afterwards, whichever way, but that's neither here nor there. It is now pending. Admittedly, till August 2021, admittedly till August 2021, the guarantees have been released. the last of the guarantees. It's a matter of argument whether to release pursuant to oral understanding out of goodness. Sometimes we have Dr. Jekyll, sometimes we have Mr. Hyde. Dr. Jekyll, Mr. Hyde, yes. So one of them, sometimes I become very good and do on my own outside, and sometimes I'm very bad and I behave badly in court. So August 21, unless it was that Dr. Jekyll character I was portraying, this was all pursuant to them. But it was performed till, but there was release of guarantees till August 21. So there cannot be limitation question arising because the refusal to perform from their side. From my side, there was the earlier refusal, which I have shown September 27 or 2017. It was the first time when in 2022, after 21, when they wrote back saying that I will not perform the March MOU. They had asked for performance of the March MOU till 2017 September. At that time, when I wrote back saying that no, I will not. But yes, I have thereafter performed that obligation, having the guarantee release. This may be one of the factors which may go against me in my readiness and willingness, though afterwards, if I have performed it, that's a question of fact before the arbitrator. Now, the issue is whether the status quo ought to have been preserved while this matter is decided by whichever forum, arbitral tribunal or suit, whichever. I can't be remediless. The status quo was being preserved because of the attempted transfers post-filing of Section 9. This is the sum and substance of my case. And I think I had shown most of the documents. Yes, my judicial point out that my aim was not, it was, their impression was given is that I was enjoying an interim order on the 17 lakh shares only. Whether they're the same shares or not, that's a question, big question mark. Till March 2023, then I withdrew my suit. And then I've come and got taken a similar order in the Section 9. That's also not correct because when we moved the application, Section 9, I did not press for interim order because there was never any threat. Affidavit directions were given. Only after they took extension of time and then they finally returned because these are all quoted companies. This is a quoted company. At post that they started transferring the shares, then only I came to. So I did not file my Section 9 just because I got the order vacated. So next day I come and file a Section note. That is not the intention. That's clear from the order. It's not even recorded as a Saraf's order that I pressed for interim order, and it was not granted. It was not pressed. Now, my lord, this is the long and short. May I show the documents which are against me? Because that is what will the September letters. Once more, I will show Justice Banerjee has seen that letter again and again because that is their, I would say, their trump card. That is in the convenience volume. CBT bolo. Convenience volume is September 22nd September CBT. In the 135 of the convenience volume. Oh, this is my, sorry, 130, 134. 134 is third paragraph of this letter at page 134. 15 September 2017. You are well aware that I had resigned from the Board of Bar in August 12 as a part of settlement of dispute between us. You were supposed to get my personal guarantee release from the Bankers of Bar. By this time, I got all the MBL guarantees. I had resigned from the board of ARP on 18th August 12, and they've never thereafter granted and guaranteed the alleged loan to Bank of Baroda. Under the circumstances, you are requested to urgently sort out the matter with the bank the earliest and keep me indemnified. You also request to share the correspondence made with Bank of Baroda after my death. To this, my reply at that time was, of course, there was no reference to the March MOU, but still, 135. The price received at the outset, I deny and dispute the contentions of it. It is denied that there exists any settlement of disputes or by which I am responsible for getting your personal guarantees released. This is a wrong, shirking my responsibility under them. Though it doesn't refer to them, or to get you indemnified on it. But this was immediately thereafter undone. Not immediately, sorry, once MBL came out of the BIF, came out of the NCL, plan was approved. That is in 2021, August. We had not suppressed, we had dealt with the letter in our pleadings.
This was the guarantee for the dues of ARP. And finally, you got it released when?
August 2021, that is at page 163 and 163 to 169.
Convenience volume.
163 is the order recording settlement and of the order of DRT and directing return of title deeds. And the implementation of the order is page 164. So that's April is the order and August it is implemented 2020. And the no due certificate followed by no due certificate. This money was paid by us. 160. Now, other letters which went unreplied by us because the MPL goes into CIRP in March 17 and the correspondence starts from April 17. 131. Not part of record. Not part of record. This is in April 17, page 131. And on 30th March 17, this company goes into CIRP. The share prices take a nosedive. Second paragraph. A civil suit is a civil suit because the suit was filed by MBLA Capital. Was filed by you by CS 54 High Court. By its order of 29th August 16, the Honorable High Court of Calcutta passed an order, injunction for the bonus share on similar. Not be out of place to mention here that we did have various rounds of discussions in person, phone after the Honorable High Court's order, wherein you assured that the transaction would be complete the first year Durga Puja 16, then again by Diwali 16, then again by December 16, then again by February 17, then again by Holi 17. You have failed to execute the transaction on any of the dates mentioned. This is all October MOU. But I am showing these replies. I'm told they are there, but they are not on record. October MOU, nothing to do with March MOU, subject matter of the other proceeding. But the letters are chosen in a very opportune moment, 31st of March 17. This company, 30th March, MBL goes into CIRP. The share price takes a nosedive. Before that, it was trading very high. And then they suddenly ask us to MBLA Capital to get the shares.
Thank you. Then
Now, lastly comes there are two letters of 13 September 22, 5 years later. 13 September to कौन page है? Sorry, 17 September 22.
17 September
2022. That was 210. When was that? January 22 is the MBL's resolution plan getting finally upheld by Supreme Court. That ends at page 209. This is the Supreme Court's order dismissing the appeal by one of the banks.
17 September Prabhu's letter. Prabhu's letter to
Prabhu's
the MPA.
letter. Sale of 34 lakh equity share. Again for the October MO.
This is page
210. 17 September 2022.
and December 20.
Yes, December 2022. 210 and 214. That's all October MOU. But these are all after the Supreme Court finally confirms the resolution plan. And then
Supreme Court confirmed on 18 January 22. Is that correct?
page 209, the bottom.
209.
At the end. 209 is the end. It starts earlier. It starts at page 18 Jan. That's page 170. It starts. October MOU 10 and 14. And so far as March MOU is concerned, my notice is page 217, 26 December 2022. It says nothing to do with withdrawal of the suit. This was well before that.
This was for amicable resolution.
The first stage of the arbitration. This is for the 17th March. This is really my kind of demand for specific performance. Their reply comes on 12th January, page 23, page 221. And Prabhu's reply? So therefore, so far now we are really concerned with the interim order against Prabhu. So far as shares are concerned, because the others we require because other companies which are to be transferred. For the Prabhu to be transferred. Page 223 is Prabhu's reply, signed by Aditya, who is the signatory to the March MOU. But his principal stand is paragraph 1 for the first that I am not a signatory to the March 13 MOU. I'm not a signatory. This is being said by a signatory, but that by a signatory who holds out Prabhu to be group 1, who signs an agreement on behalf of the entire group 1. By direct. So paragraph 1, they say that I am not party to the MOU of March 30. And this is where I would say the learned judge, single judge's order is the first flaw which would be qualifying for a intra-court appeal, because that's a fundamental flaw which kindly see the order. And
11 is still pending. 11 application is still pending.
second paragraph of the order, second and also at paragraph
Not a party. Prabhu, not a party.
admittedly, same thing, paragraph at page 35, Prabhu not a party. This paragraph 11, page 35, bottom second last line. And not only is this factually incorrect, this is the substantial pleadings are there in the section 9 petition. How Prabhu is a party. All the directors had signed. There is no rubber stamp for Prabhu. The agreements, black and white says otherwise. It says Prabhu is the party. I'm just referring to notes of notes of argument. Prabhu ke niye. Prabhu is the party. And it could not be admittedly because not only in the pleadings but in the notes of argument, there are paragraphs devoted to how Prabhu is a party because that was an argument made by them.
No, the MOU shows.
MOU itself shows. But there's no rubber stamp. The directors have signed for group 1. But whether they signed because they are also, and there's a whole chapter devoted to whether Prabhu is a party or not from page 744, that's in my notes of argument. So it cannot be admittedly for sure. And that's one of the principal contention. Apart from pleadings in section 9, but in notes of argument, several paragraphs are devoted with judgments. And in fact, if your lordship sees this from the judge, from this impugned judgment also, it would be evident that this point was argued. Kindly come to paragraph 5 of the judgment, running page 31 in the memo. Niranjan Lal Todi is only on that proposition. Paragraph 5. Niranjan Lal Todi, before the Supreme Courts have come in, this was argued before, now the Supreme Courts are very clear. Niranjan Lal Todi is our High Court judgment where even if Prabhu was not named a party in the MOU, but since all the directors have signed, family held company, MBL is quoted, but the Prabhu is a family held, fully held by family members, and all of them have signed, they would be bound by it. That is Niranjan Lal Todi's judgment. Now I'll come straight away to the judgment straight away. That is what paragraph 35. Now, you want one more? You have it so. 2011 1 CHN 762. I don't have to put my case that high because I am a party, named party. Paragraph 34. There was section 8, where the attempt was not to refer. There is then the other aspect of Sukanya holding that the plaintiffs and the 84th defendant have emphasized on that there are parties to the suit who are not parties to the arbitration agreement. There are two facets of to this aspect. The first is that the claimant who is a party to the arbitration agreement may needlessly impede persons in an action who are not parties to the arbitration agreement in an attempt to avoid reference, or to ensure the continuation of the action. The other feature could be that the parties to the action who are not parties to the arbitration agreement may be constructively or otherwise bound by the arbitration agreement. Sukanya Holdings is not an authority for the proposition that if some parties have been implemented in an action with a view to avoid the enforcement of the arbitration agreement, the judicial authority in season of the action has to reject the application under section 8. Merely on such ground. That not to suggest that some of the defendants in the present action have been deliberately implemented for the view to avoid the arbitration agreement or scuttle the ongoing reference. Notwithstanding the identity of a company being distinct from its shareholders, or even the principal persons in control thereof. Family-owned and run companies in this country are treated as assets of the family, capable of division. The Tapan Kumar Paul judgment has recognized such position. What must be appreciated is that this family intended its companies to be bound by the MOU of 89. Though the MOU contained words to the effect that the companies would be bound by the terms thereof, it does not appear to have been executed or signed on behalf of the companies. What can be said then is that the four brothers understood that their signing the agreement would bind the companies. Though in the strict sense, it may be said that the companies are not bound by the MOU, since the document was not signed on their behalf. He had signed on their behalf, but that is not how a family settlement is read or understood in this country. It's necessary to assess at the present stage. It is evident on a reading of the two primary documents and the play the family companies are bound by the MOU and the four brothers. Now, of course, the Supreme Court has made this very clear. It kindly comes now. The latest few judgments, Lordship may have come across.
Yes.
The latest few judgments on this aspect are that in any case, having slightest of doubt whether somebody should be made a party or not, slightest of doubt, it should be referred to the arbitrator. Arbitrators will be deciding this aspect of the matter. For this, Lordship kindly takes just quickly a couple of judgments. Ajay Madhusudan Patel. Ajay Madhusudan Patel দেখাবো ওখানে Coxon King quote করা আছে, so I will not place Coxon King separately. So you Ajay Madhusudan Patel and Shapurji Palanji, these two judgments.
Would you place them on the next day or?
I'll be placed them on next day. This is
when?
So when Lordship can
In
accommodate.
the second half, there's a little not uncertainty. There's a different bench for some time at 2 o'clock. তারপরে 2 p.m. at a fixed আছে. So
tomorrow morning, if it's convenient to my lords, I can come back. I don't know what is. I
কাল তো appellate side.
Keep getting confused on. Second half, I'm not there. My second half, I'm not there.
Tomorrow already a matter has been fixed at 12:30. Let it run in the list, Mr. Mitro. I will top it. We are unable to pick the time.
Friday, if it's possible. Friday, if it's. শনিবার কোর্ট আছে
Sorry about it, brother. 12:30 on Friday. Mr. Mitro, learned senior counsel, representing the appellant, resumes his argument but does not conclude. Paragraph as requested by Mr. Mitro, list this matter once again, Friday date though, on such and such, marked 12:30. এগুলো নাও এই নোটটা না হারিয়ে অনেক কষ্ট করেছি, যেটা একসঙ্গে রাখো।
Take for an extreme indulgence for and praying for him to file an appeal without certified copy.
What happened in the morning? Where were you?
This appeal wasn't prepared. That's the only difficulty.
When was the order passed?
Well, I'll just indicate that the order was passed on 17th of June. We've given the drawn up in the morning today. The urgency is this, the witness action is today.
No, Mr. Ghosh, why did your client not?
If your lordship, Declines I'll have now. I'll have. I'm only. Great. So deep.
Okay.
Sir, yes, fixed matter, item number 1.
पाँच मिनट आगे
Yes, sir.
I'm going to kindly take judgment of this division bench delivered on 17th July 2025 on under the old act, but kindly have a look at paragraph 78. এটা আছে তো? হ্যাঁ।
They've given me a copy last
কে দিল? But kindly see paragraph 78. Take it and para 17. Mr. Ghosh had argued that the arbitrator had of his own used a formula for the purpose of calculation of the claims without the consent of parties, which is not permissible. Such contention of Mr. Ghosh fails to impress us in view of the distinctive pronouncement of the Honorable Supreme Court in the case of McDermott International, paras 109, 110. I had relied on, this is exactly I had relied on 105, 106, I now also, sections 55 and 73, also, rely on this. Kindly see, 110, which is in emphasis, which is quoted here, as computation depends on circumstance and methods to compute how the quantum should be determined is a matter which would fall for the decision of the court. So, this argument of mine, is also, being, if I may say, find support, from, the last division bench, in, not. Now, the other, your lordships, would recall that McDermott was also a case under the new act. My lord, your lordships, my lord, used it, my lord, for the 1940 Act, apropos jurisdiction of the arbitrator. My lord, those matters by and large remain the same. My lord, under the 40 Act as well as the 19. Then, my lord, may I rely on, my lord, apropos scope. My lord, I just wanted that time for today because of these two new judgments, my lord, which I wanted to draw your lordship's attention. My lord, kindly take, my lord, 24th July, judgment, my lord, in BBM Enterprise. My lord, in fact, my lord, your lordship supplied, my lord, the firm Srinivas, my lord, principal, my lord, that award, my lord, was claimed, let us say, my lord, 100 rupees. But, my lord, the defense, my lord, seemed to suggest it should be 120. So there was no, my lord, problem, my lord, in awarding, my lord, 120. It couldn't be, my lord, said to be something which shocks the conscience of the court. Now, my lord, apropos, my lord, the scope of, my lord, section 37. My lord, in fact, my lord, the first leading case of the Calcutta High Court under the 1956 Act was Sindri Iron Foundry. And my lord, late father, my lord, was the draftsman of the petition. My lord, it was the first petition under the 1956 Act when it was drafted.
397.
Correct, 397. My lord, had very little particulars, was demurrable. But, my lord, they went and filed an affidavit. And in the affidavit, they disclosed, my lord, taking over of the factory, my lord, in Chasnala, and showed, my lord, that the majority shareholders stayed away from the meetings in spite of service of notice by under certificate of posting. So, my lord, that's where the phrase harakiri. And, my lord, when it was argued that these points have not been taken in the petition, so the first sentence is petition might have been demurrable. There were a lot of particulars missing, but they've all been provided by the respondent, and firm Srinivas was relied on.
Not P.B. Mukherjee, no?
No, my lord, that was, my lord, Justice G.K. Mehta and Bijoy Mukherjee, Justice Bijoy Mukherjee. My lord, in fact, Justice Mukherjee's judgment, my lord, is, my lord, the most wonderful read, because the learned Judge, my lord, was one of the most lucid, my lord, writers. The other is, my lord, painstaking on the facts, Justice G.K. Mehta. But, my lord, Justice Mukherjee's judgment, my lord, is, my lord, the one, my lord, which very few people read it, my lord, because the lead judgment is so long that, my lord, after having come, my lord, to the conclusion, my lord, and which was, and the other learned judge, my lord, judgments writing, I agree and concur, and then proceeding to write, my lord, very few people, my lord, read that. Now, my lord, kindly have, my lord, the scope of section 37, my lord, paragraph 13, kindly take. We are concerned with an appeal under section 37 of the Arbitration and Conciliation Act 1996. The appeal is directed against a judgment and order of a learned single judge of this court, allowing an application of the respondent for setting aside. What falls for our consideration is whether or not the learned trial judge acted within the parameters of section 34. It is established law by now that while exercising jurisdiction under section 34, the court does not act as an appellate court. The learned judge does not sit in appeal over the arbitral award. Learned judge has to see only if the petitioner assailing the award has been able to make out at least one of the grounds for setting aside an arbitral award as mentioned in section 30. Then, my lord, section 34, my lord, is set out. Kindly come to, my lord, para 15 at page 17. Tell them to run. Then, my lord, on a perusal of the aforesaid section, it would be clear that the grounds of challenging an arbitral award has not been restricted by the legislature. Under the Arbitration Act 1940, an award could be challenged on various grounds. This resulted in prolongation of the process of resolution of disputes between the parties by resorting to arbitration as an alternative dispute resolution mechanism, since in a large number of cases, the arbitral award was challenged before the competent court. Thereafter, the legal process continued up to the Honorable Apex Court. The intention of the legislature of making arbitration an expeditious procedure for dispute resolution was often defeated. This was one of the reasons for promulgation of the 1996 Act. The grounds of challenging an arbitral award are now limited, as would appear from the opening words of subsection 2 of section the grounds of challenge mentioned under section 2 are exhaustive. Not illustrative, but exhaustive. An arbitral award may be set aside only if one or more of the grounds enumerated is made out by the. Subsequently, subsection 2A was introduced, which provided an additional ground for setting aside an award. And may I add also, explanations, also came in, by the amendment. One of the grounds for setting aside an award is if it is in conflict with public policy of India. Explanation 1 under subsection 2 clarifies when an award can be said to be in conflict with the public policy of India. One such situation is when the award is in contravention of the public policy of India. Explanation 2 under section 2 clarifies that in order to ascertain whether there is a contravention, court shall not review merits of the dispute. Under subsection 2A, your Lordship, paraphrases it. Then, kindly see para 18. We therefore see that the intention of the legislature was to reduce the role of the court to the minimum so that there is minimal interference in the arbitral process by taking recourse to court. The learned single judge has noted the decision of this court. Then, that is set out. Now, kindly come to paragraph 27, page 25. It is too late in the day to dispute the proposition of law that the arbitrator is the ultimate master of the quantity and quality of to be relied upon. The finding of an arbitrator on facts will rarely be interfered with by the courts. Similarly, insofar as the construction of clauses of a contract is concerned, the arbitrator's opinion will generally be accepted. Of course, if a finding of fact or an interpretation of a contractual clause is perverse on the face of the award, the courts may justifiably interfere. Then, kindly come to para 41. Your Lordships interfered because the express finding was, para 41. The learned trial judge, while noting the relevant decisions which have laid down, has however failed to apply the correct principles of law to the facts. Learned trial court acted as an appellate court rather than a court in season of an application, performing the restricted function of deciding whether on. In my view, learned trial court has transgressed the jurisdiction. Now, these two decisions, in my respectful submission, support my case. Now, one note, was filed. File which I wish to deal with, since first supplementary note, kindly have a look. If it can't be found, I have copied. Yes. I just want to deal with the case, which has been. Because, my arguments deal with, kindly take para 7 and 8.
No, this is not the one then. There is no para number.
But I have a copy. This was filed. It says summary of arguments on behalf of the appellants by learned additional solicitor. Paragraph 7 and 8,
Yes.
Furthermore, the courts have held time and again that while granting compensation for breach of contract, it is imperative to determine whether the parties suffering breach took any steps to mitigate its damages. However, the award in the present case also ignores this dictum in its entirety. Additionally, which naturally arose, interpreted as prohibiting the award of any remote or indirect, has been awarded sums towards it would earn had it been able to use the rigs for the purpose of Moreover, such compensation has been awarded on the assumption would have earned profit by when the contract neither contemplates transportation of any particular type of goods in carrying, nor contemplates assignment. So on. Now, my lord, what is, my lord, being talked about? My lord, is a duty to mitigate, my lord, to start with. My lord, the law, my lord, is there is no absolute duty to mitigate. My lord, one has to show, my lord, that the damages suffered could have been avoided to some extent. Now, my lord, that is, my lord, before this duty, before any, my lord, argument can be made as to measure of damages. My lord, it has to be shown, my lord, that there was, my lord, there were certain steps, my lord, which could have been taken, my lord, when, my lord, they acted in breach, my lord, of the contract. Now, my lord, kindly imagine the situation. My lord, first they have not, my lord, disclosed, my lord, what could the steps have been. That is number one. Number two, and my lord, this is very important, my lord, they are, my lord, in control of the rakes. My lord, it's coming from the pool. It is not my rake which necessarily I get. I've put mine in the pool. They have control over it. I only have, my lord, a right of preference, my lord, a bonus, and, my lord, a freight rebate. My lord, if they don't give it, my lord, with the greatest of respect, if I may ask, my lord, a question in the form of a submission, what do I do to mitigate? Can I go elsewhere, my lord, to get the rakes, my lord, at, my lord, with a freight rebate? Can I go elsewhere, my lord, to get a preference with regard to allotment of rakes? Can I, my lord, go elsewhere, my lord, to get, my lord, a bonus? With the greatest of respect, my lord, it's not possible. In fact, your lordships would recall, my lord, the lead case regarding mitigation of damages. My lord, actually, my lord, the knowledge here, my lord, is picked up, my lord, as, my lord, the law evolves. But, my lord, in our country, my lord, it has been laid down succinctly, my lord, right, my lord, and there's really not been much change. My lord, this is Lachya Setti's case, my lord, your lordships would recall. My lord, 1980, 4 Supreme Court cases, 636. Kindly take, my lord, paragraph 14. Which he has disclosed. Now, my lord, kindly come to para 14. At page 645. At the outset, it must be observed. Sorry, my lord, 645. This is, my lord, copy. 1984 Supreme Court cases 636, para 14. At the outset, it must be observed that the principle of mitigation of loss, kindly mark this, does not give any right to the party who is in breach of the contract, but it is a concept that has to be borne in mind by the court while awarding damages. The correct statement of law in this behalf is to be found in Halsbury's Laws of England, 4th edition, volume 12, so and so, which runs thus. Plaintiff's duty to mitigate loss. The plaintiff must take all reasonable steps to mitigate the loss which he has sustained, consequent upon the defendant's wrong. And if he fails to do so, he cannot claim damages for any such loss. Kindly, the next is very operative. My lord, the operative portion, which he ought reasonably to have avoided. Now, my lord, this is common law developing. My lord, a contract act by itself, my lord, doesn't have it. There's a principle, my lord, on what basis, my lord, this, my lord, mitigation, my lord, came in. My lord, the reason was, my lord, that, my lord, resources should be made free. So, my lord, and resources should be utilized. Therefore, if you can get it somehow, do it. And person who's broken, let him go. But don't suffer for it. Get something. In fact, your lordship's aware that if I take steps to mitigate, if I could take steps to mitigate, if I incur expenses and a loss, well, the defendant, my lord, becomes liable for that also. Now here, my lord, what could I do, my lord, to mitigate? It has to be seen. which, my lord, he ought reasonably done to have avoided. I'm, my lord, giving your lordships, my lord, the scenario. It's the pool, my lord, of the rakes. He has to make available the rakes. He has to make freight rebate available. He has to make, my lord, bonus rakes available. He has to give preference in allotment of rakes. Where do I go, my lord, for this? I'm, my lord, continuing, my lord. Now, my lord, kindly see. Again in para 1194 at page 478, the following statement occurs under the heading, my lord, standard of conduct required by the plaintiff. The plaintiff is only required to act reasonably, and whether he has done so is a question of fact. Kindly mark this, my lord. Question of fact in the circumstances of each particular case, and not a question of law. He must act not only in his own interests, but also in the interests of the defendant, and keep down the damages so far as it is reasonable and proper by acting reasonably in the matter. In cases of breach of contract, the plaintiff is under no obligation to do anything other than in the ordinary course of business. And where he has been placed in a position of embarrassment, the measures which he may be driven to adopt in order to extricate himself ought not to be weighed in nice scales at the instance of the defendant whose breach of contract has occasioned it. He has no right. It's a measure of damage. Now, my lord, kindly, the plaintiff is under no obligation to destroy his own property or to injure himself or his commercial reputation to reduce the damages payable by the defendant. Furthermore, the plaintiff need not take steps which would injure innocent person. In Banco de Portugal, Lord Chancellor Lord Shanky quoted with approval the statement of law enunciated in James Finlay to the effect. In England, the law is that a person is not obliged to minimize damages on behalf of another who has broken a contract if by doing so he would have injured his commercial reputation by getting a bad name in the trade. In American jurisprudence, so-and-so contains the following statement: the general doctrine of avoidable consequences applies to the measure of damages in action for breach of contract. Thus, the damages awarded to the non-defaulting party to a contract will be determined and measured as though that party had made reasonable efforts to avoid the losses resulting from the default. Some courts have stated this doctrine in terms of a duty owing by the innocent party to the one in default. That is, the person who is seeking damages for breach of contract has a duty to minimize those damages. However, kindly mark this, on analysis, it is clear that in contract cases, as well as generally, there is no duty to minimize damages, because no one has a right of action against the non-defaulting party if he does not reasonably avoid certain consequences arising from the default. Such a failure does not make the non-defaulting party liable to suit. It only indicates that the damages actually suffered are greater than the law will compensate. Therefore, in contract actions, the doctrine of avoidable consequences is only a statement about how damages will be measured. My lord, your lordships would have noted, my lord, how thoughtfully, my lord, the Supreme Court has, my lord, provided in italics, my lord, the real, my lord, ratio, my lord, of, my lord, the decisions and the statement of law in Holsbury. Makes it easier for us to understand the Supreme Court judgment. Then, my lord, from the above statement of law, it will appear clear that the non-defaulting party is not expected to take steps which would injure. If so, then steps taken by him in performance or discharge of the statutory duty also cannot be weighed against him. In substance, the question in each case would be one of the reasonableness of action taken by non-defaulting. The greatest of respect, my lord. Firstly, this issue, my lord, should not, my lord, detain, my lord, your lordships at all, because, my lord, your lordships examining the, my lord, decision of, my lord, the learned single judge, whether it's kept, my lord, 34, my lord, in mind. Has, my lord, really followed, my lord, the mandate, my lord, of section 34. But I, my lord, thought, my lord, since these notes are also, my lord, my lord, with your lordships, next, my lord, is, my lord, the supplementary note, my lord, which was given, my lord, along with, my lord, the service, Amar Boita service. made a photocopy. Millet, the last occasion, my learned friend made over Millet, chapter 5 of the Finance Act, and Millet a note, extract of chapter 5. দিয়েছো তুমি নোটটা দিয়েছো Well, the note is there, I believe. আছে তোমার কাছে পুরোটা ফাইন্যান্স একটা দিচ্ছ না হ্যাঁ হ্যাঁ দিয়ে দিচ্ছি আমি Do you have this? Note na act. Act, my lord, don't bother. I'll give the, my lord, full act. There was a problem, my lord, on the last occasion because the relevant provisions were not, my lord, there, my lord. Now, my lord, kindly take the note once. My lord, the loss of profit, one of the materials, my lord, relied upon by, my lord, the arbitral tribunal were, my lord, invoices, my lord, which were, my lord, raised, my lord, on Sesagua, my lord, for transportation, my lord, of their goods. Now, my lord, kindly come to the point, my lord, which they, my lord, raise now, which I, in my respectful submission, my lord, should not be permitted at all. My lord, the point which they raise, my lord, is, my lord, kindly come to page 2. They say the invoices do not show any service tax. Therefore, it should be presumed that those invoices are fraudulent because this was a taxable service under the Finance Act. And there has been fraud. Now, my lord, I want to tell your lordships, my lord, one thing. My lord, this was not a point urged, my lord, in the section 34 or, my lord, before the arbitral tribunal. And, my lord, they were all disclosed. This point was not taken. And, my lord, third, my lord, is, my lord, grounds of appeal. Grounds of appeal. This is not even there in the grounds of appeal. And there is no pleading. So, my lord, an issue of fraud, my learned friend, my lord, wants your lordships to decide for the first time as a ground for setting aside, my lord, in the appeal court. My lord, in my respectful submission, this is impermissible. My lord, fraud can unravel all, but it has to be brought to the court's notice or the tribunal notice at the appropriate time. It was not, and it is not simply a question of law. My lord, fraud, my lord, is, my lord, a quasi-criminal charge even in civil proceedings and has to be established beyond reasonable doubt. Today, without a pleading, my lord, you just can't come and say there's fraud. So, my lord, in my respectful submission, this should not have happened at all. Now, my lord, kindly have a look at what they are referring to. My lord, they, my lord, say, my lord, kindly come to, my lord, page, my lord, 1, my lord, third paragraph. It is submitted that while submitting the claim for loss of profit by the respondent has been tried to be proved by two agreements dated 8 September 2009 and 6 October 2009 between the respondent and Sesagua. My lord, they have been mentioned. From the agreements, it can be found out that the WIS benefit of the respondent was subcontracted to Sesagua for the months of September and October 2009, and that too for export through Haldia. The respondent had filed 15 bills in annexure LL3 issued by the LL, my lord, 3 is the footnote, issued by the respondent in favor of Sesa Goa Limited from 21st September 2009 to 16 November 2009, which is also evident from the chart at Annexure JJ, wherein details of the bills have been provided. None of the bills which form part of Annexure LL has a service tax component incorporated in them. The total value of the bills is 1 crore so and so, and each of the bills is more than rupees 10 lakh. Then, my lord, taxable service, etc. Now, it a copy and the act. What is this? See, that's what I tell you. People come, go without understanding it. It's impossible, and you have to take responsibility. You were sitting there. My lord, kindly take my book, my lord, and if you can't get it, at least put in a request here. My lord, kindly, I'm just the section. My lord, kindly take section 60. Just kindly note it. I'll hand up my book, my lord. My lord, section 65. My lord, subsection 105. And my lord, ZZP. My lord, I'm just flagging it, my lord, for your lordship's kind. I'll get the photocopy, my lord, of these relevant provisions. If you can't do it, give it to me. I'll go to the footpath and get it done. Photocopy. My lord, taxable service was what had been left out. What are you talking? My lord, there are yellow and pink, my lord, flags. Kindly forgive me, my lord. I'll just get the
No problem.
photocopy. It's not there, my lord. You know, that
Not in this.
my lord, they missed it out last time, my lord. 105 they missed out last time. My lord, kindly come straight away, my lord, to the definition. My lord, 105. Taxable service means any service provided or to be provided. Then, my lord, kindly come to any person by a goods transport agency in relation to transport of goods by road in a goods carriage. Now, triple ZP, please, what are you reading? You have also not understood. Right here. It's there, ma. But 1 minute, 1 minute. Lord, your lordships have P, my lord. To any person by any other person in relation to transport of goods by rail in any manner. Lordships have that. So they say here, your invoices didn't disclose this. Kindly see the period, my lord, of the invoices. My lord, it's in the note. It's given in the note. 21st September 2009 to 16 November 2009. Now give me the exemption. Now, my lord, it's very easy, my lord, my lord, I can show, my lord, that, my lord, service tax is not payable even otherwise. But, my lord, there was an exemption notification for, my lord, this provision. my lord, on 1st of September 2009. My lord, kindly take the second page of, my lord, that Gazette, my lord, publication. Kindly see, my lord, in exercise of the powers conferred by subsection 1 of section 93 of the Finance Act, herein, and this is 1st September 2009, the central government, on being satisfied that it is necessary in the public interest so to do, hereby exempts the taxable service provided to any person in relation to transport of goods by rail as referred to in subclause ZZZP of clause 105 of section 65 from the whole of the service tax leviable thereon under section 66 of, provided nothing contained in this notification shall apply to any service provided or to be provided by any person other than government railway in relation to transport of goods in containers by rail. This, my lord, was not even applicable. And it's raised, my lord, with a serious allegation, my lord, of fraud. And for the first time. My lord, I'll have the relevant provisions of the Act, my lord, photocopied, and hopefully we'll get it right, my lord. My lord.
Yes, Mr. Lahiri.
My lord,
Anything
may I-
else?
My lord, may I have your lordship's kind leave, my lord?
Yes.
My lord, everybody is excited about me showing more. My lord, I don't think it's necessary. I want to improve my case.
Yes, we have been calling you.
No, I understand. No, I have. I don't know if he has finished or not. I have.
Yes,
My lord,
yes.
may I have your lordship's leave, my lord?
Yes, yes.
But can I come back? My lord?
What will you come back for?
The new judgments, my lord, on the judgments. On the judgments.
You could have finished it off today, Mr.
I
Lahiri.
understand. Wednesday I'll come back. Anytime Wednesday, 10 minutes when I'll come back. I'm out
10 minutes, 10 minutes.
10 minutes.
Hey, 15 minutes.
This, my lord, what he has given, my lord, to utmost respect. But we'll see the proviso.
We have seen. Why should we even go into it, Mr. Lahiri? Anyway, we'll see. পরশুদিন কটার সময় হবে? কখনোই হবে না। We'll keep it again on Wednesday at 2 p.m. But
10 minutes. I'll finish.
Very well. 11.
1 p.m. will be safer. 1 p.m. 15 minutes will be bound.
12:45 something is fixed already. Mr. Mukherjee, Kamalan, senior advocate representing the respondent, concludes his argument. Paragraph on the request of Mr. Lahiri, learned advocate appearing for the appellants, let this matter be listed again on Budhbare date thou, marked 2 p.m. Or would you prefer 12:30?
12:30 is also.
1 o'clock is a better time on any day.
No,
12:45 already the matter is fixed.
12:30, what happens, man? Sometimes the matter gets spilled
No,
over.
no. Lordship has a matter at 1 o'clock. Can you keep it at
12:45 is a fixed matter.
12:45.
Man, what happens is there are fixed matter.
You want 12:45 or 2? At 12:30 or 2?
12:30 to 12:45. 15 minutes.
So, man, if an ongoing matter is going on, then 12:45 matter will get preference.
2 p.m. Come back at 2 p.m. 2 p.m. to enable him to advance his argument in reply.
Okay.
Appeal from 3, item number 3.
Arrested for your victor, you are comfortable.
ষোলো তারিখে পরে
আমি 11
ষোলো দেখো ওই দিকটা কি করবে
second time time is
কিচ্ছু মনে নেই কি বলে ষোলো ষোলো
Please, my lords, I'm appearing for the appellant in the matter. My lord, I'm praying. Item
A.K.
number
Ghosh.
3, my lord,
A.K. Ghosh.
my lord.
Yes.
And I'm praying for an adjournment.
Yes,
My lord,
yes.
may I
How long?
only
Kela?
pray, my lord, the week starting from 11th of August, my lord, any day thereafter that suits your lordships, my lord.
Any day starting 11th of August.
11th of August, my lord.
Week starting for 18th of August.
18th of August.
My lord.
18th?
18th will be there. my lord. It's a Monday.
Made by Mr. Bagh, learned advocate representing the appellant, let this matter stand adjourned and be listed again on August 18, 2025,
Deeply obliged.
retaining its position.
I'm very deeply obliged.
Number 4.
Kindly make it. My lord, item 4, my lord, kindly make it. আগের অ্যাপিলটা চলবে তো আছে। Your lordship, not kindly make this not today, not the item 4, my lord.
Yes.
I think, my lord, they expected my junior, my lord, probably thought that the previous matter will go on for some more time. I'm
Not
so sorry.
today,
my
not
lord.
today.
I'm great.
5 and 6.
For the appellant.
Respondent? Keith, you respondent. Pass it over. Let us see the second call.
No, 7 and 8.
I appear for the appellants in item 8, your lordship.
Lordship, in this matter, I am praying short passover, Lordship.
Pass over.
Number 9.
my lord, I appear for the appellant, my lord. Mr. Joyanta Mitra is on his way, my lord. If your lordships may take it up in the second call.
You are for the respondent? Pass over. Chalo.
I appear for the respondent in this matter.
Next. Yes.
Being led by Mr. Shantan Vasu, he is on his way. Lord, may it be passed over.
Pass over.
7, 12.
I am appearing for the appellant in 11 and for the respondent in item number 12.
Pass over.
Lord, I have for the appeal, my lord, it is section 37 appeal, my lord. We have filed the paper books, my lord. And on the last occasion, your lordship's pleasure was that the record for section 34 has been called out. Now, we find that the rejoinder in one of the section 34 application is not available either with the respondent or with us. Definitely, we take an inspection of the record and I will file a supplementary paper book, my lord, bringing on record that. And that permission may be given. Leave may be.
Leave is granted to the appellant to file supplementary paper book, incorporating therein certain papers which have been inadvertently missed out. Let such affidavit be filed, paper book be filed within
2 weeks, my lord.
2 weeks from date. Paragraph lists the matter 2 weeks hence, date diye dao. Some papers they have missed out.
My learned senior has indicated to me.
Grateful to you. Deeply appreciate.
Next.
My lord, in item number 17, the appellant were facing some problem in the department of filing the documents. Probably they have filed the documents in the department.
What documents?
The paper book.
Paper book. The department is not accepting the paper book.
That's what they have mentioned in the last day.
Oh, you are for the respondent?
I'm for the respondent.
Oh, কি হলো বলো তো? তাহলে? You don't have a copy? The paper book?
I have. They have served on me.
Pass over, চলো, second call করো.
Second call. Item number 5 and 6.
I am for the respondent. But we have filed our written note before your lordship, so has the appellate.
My lord, this is so the appeal has been preferred, my lord, against the order rejecting the application under section 34, mainly on the ground of jurisdiction. My lord, I shall try to impress your lordship firstly upon the point that there was no arbitration at all being held. My lord, if your lordship goes to the paper book, my lord, kindly I take note of the paper book, my lord, page number 13. Yes, page number 13 regarding, my lord, part 2, my lord, APOT number 326. AP number,
330 দুটোই সেম আছে ইপিও নাম্বার কোনটা দেখাচ্ছে হ্যাঁ 163
163 my lord, kindly see. My lord, kindly see page 13, your lordship, page 13, internal page 13. My lord. My lord, got it?
Yes.
Yes. My lord, page 13, your lordship, that is order dated 29th of December 2022. My lord, on that date, my lord, this respondent filed an application under section 9 of the Arbitration and Conciliation Act 1996, my lord, that has been registered as miss case number 7612 of 2022. And that miss case was moved on 29th of December 2022. And on the said date, my lord, it has been stated by the present respondent. Lord, kindly see, my lord, the last paragraph, my lord. It appears from the agreement that all differences, disputes are to be referred to an arbitrator appointed by the petitioner. In the case the arbitrator is not appointed by the petitioner in terms of the relevant agreement, However, as the petitioner apprehends that there is every possibility of selling, alienating, or encumbering the vehicle in question, this court is inclined to allow the prayer of the petitioner on condition that petitioner shall refer the matter to the arbitrator within 90 days from the date of this order. Well, on that date, my lord, that is 29th of December 2022, it has been, my lord, admitted by the present respondent that no arbitrator has been appointed and matter shall be referred to arbitrator. My lord, kindly see page 33. Page 33, my lord, on that date, my lord, this respondent filed an application under Order 7, Rule 11 in connection with my suit, title suit, which I filed, and in the said title suit, the present respondent took the point that he has obtained an award. Obtained an award, well, kindly see, award dated 1st of November 2022. My lord, that will appear, my lord, in your third paragraph number third paragraph, my lord, that upon hearing dependent company, the learned arbitrator has already published his award on 1st November 2022. Since the plaintiff did not appear before the arbitrator to contest the arbitration proceeding. Well, I am asking to myself, my lord, when in the month of December 22, they are saying that no arbitrator has been appointed, then how award can be passed before the appointment, that is on the month of November? I am asking to myself, my lord, is it possible? My lord, very thing, my lord, how I have been defrauded or my lord, I have been deprived. I am trying to draw attention of your lordship. My lord, then my lord, kindly see how award has been passed. My lord, it will appear from, my lord, what does it? My lord, that will award, your lordship will find from page number 126. Yellow. Lord, Lord, award, my lord, kindly see how many agreement has been, my lord, consolidated. My lord, so different agreement, contract number is different. My lord, page 128, your lordship will find that different contract and different agreement, and all has been clubbed together, and on clubbing together, my lord, an award has been passed, and that appointment is unilateral appointment, my lord, not by the consent. There is no document, my lord. From the averment of the award, your lordship will not find that, my lord, any appointment consent has been granted by the present appellant or appointment has been made by the arbitrator. My lord, no notice of the appointment of the reference under 21, no notice under reference under 21, no notice for, my lord, attend hearing, no notice for hearing of the arbitration, my lord, no opportunity to, my lord, to contest the proceeding, my lord. Well, thereafter, my lord, this award has been passed, and my lord, and when passed, my lord, kindly see, it has been passed in the year 2022. When, my lord, there was no commercial court in city civil court. My lord, your lordship knows that in the year 25, this year, my lord, one judgment has been passed by Honorable Justice Sabyasachi Mukherjee, and by virtue of the judgment, an order has been passed, my lord, directing the, my lord, passed holding that all the judges of the city civil court will function as, my lord, a commercial court, and that is in the year 25. My lord, there had been no 7 except the High Court, my lord. That's why, my lord, section 34 was filed before here, my lord. My lord, before that, my lord, a dispute arose, my lord, as to whether city civil court shall be, well, your lordship knows that arbitration proceeding can only be held by the principal civil court of a district or before, my lord, High Court. That is section 2 says, my lord, either it will be heard by the principal civil court of a district or by a High Court. My lord, a dispute arose, my lord. Your lordship, I suppose your lordship is aware of the matter, my lord. One judgment was passed by Honorable Justice Sanjeev Banerjee, holding that city civil court is not the principal civil court. Another judgment was passed by Honorable Justice Horish Tandon, and his lordship was pleased to hold that city civil court is the principal court. And due to the divergence of the, my lord, pronouncement, my lord, the matter was referred to the division bench, and, my lord, division bench, my lord, that was, my lord, constituted with, my lord, Honorable Justice Indira Banerjee and, my lord, I suppose Sohidullah Munshi, and, my lord, Mr. Gopal Ghosh was the advocate for the appellant, and that appeal was heard, and on hearing, my lord, the matter was heard, my lord, on hearing, the division bench was pleased to hold that in case of a, my lord, award which is up to the extent of value of rupees 10 lakhs, in that matter, my lord, civil court can hear. Otherwise, it will be heard by the division bench, High Court, my lord. So, my lord, I had in the year 2022, I am to file section 34 within 120 days maximum, not beyond that. So that's why, having no forum available, my lord, I had to file here, my lord. But and the matter was considered when my Honorable Justice, my lord, Somen Sen, along with Mr. Biswarup Chaudhary was here, my lord, and the matter was considered, and his lordship expressed that he has passed an order to that effect that no one can be, my lord, without, my lord, remedy. So, in a similar matter, he has passed an order. That's why, my lord, my friend was also here, and, my lord, a order was drawn that whatever was due up to the December 2022, that amount is to be paid. And, my lord, and both parties were directed to file affidavit. We have filed, my lord. We have filed stating that whatever the due, my lord, as it does not, my lord, match with them, my lord, they turn down around, my lord. Whatever may be, my lord, my lord, my case is that whether it was proper on my part to file the application under section 34 in this court, or, my lord, whether it was, my lord, within the it was proper for the, my lord, the single bench to turn down my application under section 34. Well, whether my friend argued that since the since after the order being passed by Honorable Justice Indira Banerjee in the division bench, my lord, commercial court act has been, my lord, published. So, my lord, that judgment will not stand in the way. But, my lord, I am submitting humbly that, my lord, so long the court is not functioning, my lord, see, I cannot file my application under section 34 when the, my lord, value of the award is far more than rupees 10 lakhs. My lord, I cannot file it before the city civil court. So I may not be left without the remedy. So I have filed the same, my lord, without determining that aspect of the matter, my lord. The application has been dismissed on the ground of jurisdiction, my lord, which I, my lord, submit before your lordship to invoke the jurisdiction of the appellate court and to, my lord, to undo the my lord, wrong which has been done to me according to my lord, and to do the needful, my lord. My lord, I have become, my lord, destitute at the instance of the other side, my lord. So many of the vehicles have been taken away without, my lord, giving opportunity to defending my case, and this is the, my lord, position, my lord. Kindly, my lord, I also previously requested your lordship, my lord, to have some attention to this record. Your lordship is taking attention of all record. I have no, my lord, dissatisfaction, my lord. Kindly, this is the position, my lord, and the judgment, my lord, which I am referring, my lord, that judgment, your lordship, kindly take note of the. AIR 2015, Calcutta, page 335, my lord. আরেকটা কোথায় গেল? আরেকটা কপি দাও। হ্যাঁ, আরেকটা কপি আছে? হ্যাঁ, হ্যাঁ, শুনুন, আরেকটা আছে তোমার কাছে? My lord, I shall give another copy, my lord. One copy is আরেকটা কপি আছে। হ্যাঁ, this is my long and short of my. Are Baba, written notes, my lord, I have filed written notes, my lord. বললাম পরে। আরে চুপ করো না, আশ্চর্য হ্যাঁ, প্লিজ বসুন। My lord, one point I have left, my lord. They have taken the point, my lord, section 42, they have taken the point.
Yes. What is your answer to that?
Answer to that, my lord. My lord, I have not approached the city civil court, my lord, by filing any, my lord, application under the arbitration act.
They have.
They have. And in that, and a receiver was appointed in that matter. My lord, your lordship knows that the court which appoints the receiver, that court can only discharge the receiver. So that, since my vehicle has been taken away by the receiver, I made an approach before that court to discharge the receiver. So I have not followed by any application under the Arbitration Act to so that 42 will be invoked in my.
Yes, Mr. Chakravarti, it is not necessary for you to approach.
And
if the court entertains any application of any party, then under 42, all subsequent applications.
My answer is I have not approached under section 34. And above all, my lord, whether, my lord, if I have approached the court, if section 42 is also applicable to me, even if, then whether I can, my lord, enlarge the jurisdiction, pecuniary jurisdiction of a court, if it is held that the court has jurisdiction up to the extent of 10 lakhs only, whether I can enlarge the jurisdiction since section 42 is applicable.
Between 10 and 1 crore concurrent.
Court jurisdiction will not be enlarged. Is it logical that since you have filed application, so even if court has no pecuniary jurisdiction, you are to file there, not in other court? Well, this is my answer.
Your application under section 34 is at page 64.
Yes.
Both the matters, why two matters? Or two arbitration awards.
Two awards.
Issue. We point to suggest. দুটো একসঙ্গে appeal নেবেন, হ্যাঁ? These two appeals,
Similar facts in both the matters.
these two appeals arise out of two arbitration petitions. Mr. Banerjee, Mr. Chakraborty, just please hear what we say. Factually, if we go wrong, correct us. Two arbitration petitions whereby the appellants, appellants, challenged two arbitral awards passed in favor of the present respondent by a learned sole arbitrator. Stop. The learned paragraph. The learned single judge dismissed the two applications under section 34 of the Arbitration and Conciliation Act, 1996. Not on merits, but on the ground that the same were not maintainable in the High Court. Stop. This is because prior to the setting aside applications being filed, the respondent herein had approached the City Civil Court at Calcutta with a post-award with a corona must have filed several section 9s in different matters with with post award section 9 applications for interim orders to protect the vehicle of the respondent, which had been leased out,
It was under hypothecation.
which were in the possession of the present appellants under hire purchase agreement.
Yes.
Under hire purchase.
Actually, my lord, loan come hypothecation.
Under
agreement.
loan come hypothecation agreements. Stop. Such applications under section 9 were entertained by the learned city civil court and protective orders were also passed. Stop. The present appellants approached the learned city civil court with applications for vacating the interim orders passed in favor of the finance company. Stop. Paragraph. In the above factual background, the learned single judge held that in view of section 42 of the 1996 Act, learned city civil court at Calcutta is now clothed with exclusive jurisdiction to entertain all further applications arising out of the concerned arbitration agreements. Stop. Accordingly, the learned judge dismissed the 2 arbitration petitions. Stop. Being aggrieved, the petitioners before the learned single judge are before us by way of these appeals. Paragraph. Section 42 of the Arbitration and Conciliation Act reads as follows. এখান থেকে এটা সেট আউট করে দেবে no 42 দেখতে পাচ্ছ? হ্যাঁ 42.
It is quoted in our written note as well.
I have not even opened your note. Learned senior counsel appearing for the appellants raised various grievances. Stop. He said that firstly, the appointment of arbitrator was made unilaterally. Stop. No consent of the appellants was obtained. Stop. No notice of arbitration was served on the appellants. Stop. The appellants had no opportunity to contest the claim of the finance company. Stop. Therefore, the award is not sustainable in the eye of law. Stop. Paragraph. All these points the appellants would be entitled to urge before the forum having jurisdiction to entertain his challenge to the concerned arbitral awards. Stop. In view of the clear wordings of section 42 of the 1996 Act, which was incorporated in the statute to avoid conflict between courts, it is the city civil court alone which is competent to entertain the setting aside applications of the appellants herein. Stop. Hence, the learned judge was perfectly justified in dismissing the applications of the appellants as not maintainable in this court. Paragraph. The contention of the appellants that the City Civil Court does not have pecuniary jurisdiction in the matter is also devoid of merits. Stop. The learned judge has dealt with this point in the judgment and order impugned before us, and we agree with the learned judge. We agree with the conclusion of the learned judge. Stop. Paragraph. In view of the aforesaid, we find no reason to interfere with the judgment and order sought to be assailed before us. Stop. We affirm the impugned judgment and order in as much as to the extent it holds that the setting aside applications were not maintainable before this court. Paragraph. We have not gone into the merits of the challenge of the petitioners to the arbitral awards in question. Stop. If the appellants are entitled to challenge the arbitral awards before the appropriate forum in accordance with law, they shall be at liberty to do so. Stop. If such a forum is approached by the appellants, we request such forum to decide the appellant's challenge in accordance with law, upon hearing all parties, without being influenced by any observation in this order.
My lord, delay to be, my lord.
Section 14. 14 the benefit.
Lord, I would be
Objecting to?
Section 14. Lord, in accordance with law is sufficient. If
No,
we are
no,
entitled
not
to
sufficient,
section
not
14,
sufficient.
that would be prejudging, my lord.
No.
My most humble submission.
Lord, at that time, my lord, no jurisdiction was there. Otherwise, my lord, it will be totally, my lord.
But may I make one humble submission?
He is asking for the benefit of 14. We are not going to grant him. What we are going to say only, if he raises that point, the forum will decide that point. That is all.
My lord, some hints may not.
Some?
Some, my lord.
Yes. Paragraph lekho. Mr. Chakraborty, learned advocate for the appellants, says that we should grant the appellants the benefit under section 14 of the Limitation Act. Stop. We are not inclined to do so. Stop. However, we are not inclined to do so in these proceedings. In these proceedings. Stop. However, if such point is raised before the forum which the appellants may approach, that forum shall decide the same in accordance with law. Duto appeal disposed of. In this order. এটা রাখবেন না?
Lordship, in this matter, I appear for the appellant in item 7, Your Lordship.
And I appear for appellant for item 8, Your Lordship.
Lordship, on the last occasion, I had filed an application under Order 41, Rule 27 to bring on record additional documents, Your Lordship. However, Your Lordship, due to an inadvertent error, Your Lordship, one of the last annexure is missing. So I seek Your Lordship's leave to file a supplementary. It has subsequently been discovered, Your Lordship. Actually, that's missing. It's a
Inadvertence. How many times they are
Firstly, you file an application to disclose documents which you did not disclose before the learned.
disclosed all the documents barring one document, Your Lordship, due to an inadvertent mistake on the part of the junior, Your Lordship. It's been missed out.
How long?
Your Lordship, a week's time. I'll be
Learned
grateful if
advocate
Your
for
Lordship
the,
can-
yes, for the appellant. Learned advocate for the appellant.
For the
in-
appellant.
You are, who are?
7.
Pune Nagel, Your Lordship.
Pune Nagel.
Yes.
In AOCOM 26 of 2024 says that prays for leave to file a supplementary affidavit in connection with the appellant's application under Order 41, Rule 27 CPC. Stop. Let such affidavit be filed within a week from date with advance copies to learned advocates for the other parties. With advance copies to learned advocates for the other parties. Stop. List the matter 1 week hence.
It will be Your Lordship's pleasure to pass directions for affidavit in the main application.
There's a stay application.
No, in the
application.
41.
You want to file opposition to that?
If Your Lordship, but
We will consider that along with the appeal, as we always do.
in that event, my lord, we will reserve our right to file it at that.
No, file then. File. Paragraph.
Need much time, my lord. Only a week's time would be enough.
Lordship, usually, with all due respect, usually it's considered along with the appeal.
It will, but along with their affidavit in opposition.
Very well.
They have to make out some valid ground, which is not there.
Learned,
These documents have a direct bearing, Your Lordship,
the
on the issue at hand.
respondents in this appeal will be at liberty to file their opposition to the appellant's application for disclosure of additional documents within a fortnight from date. Let them give you the supplementary affidavit. Stop. You want to file a reply? Not necessary.
Lordship will kindly give us an opportunity.
Stop. Reply there to, be filed within a week thereafter.
Thereafter.
Paragraph list the matter 3 weeks hence. 3 weeks hence. List the matters korbe, duto achi action 7-8. 3 weeks hence. Chalo.
Deeply obliged.
Obliged, Your Lordship.
Aschinto. Mr. Mitru, we would have been happier if you were back home and resting, if you were resting. It's always a pleasure to hear you. That's not the point, but we feel concerned.
No, I am otherwise all right, man.
You can carry on for 15 minutes if you like, because we have fixed a matter at 3:30.
3:30 minute, I am there in that matter.
Oh, I see. Then
So,
you can.
I would much rather have that done.
Then we can take that up if other learned advocates are here. কোনটা 3:30?
আরে other side এ কথা হচ্ছে
Give it at
তোমরা তো
3:30.
সবাই আছো. You people are all there. Sit down. এটা কি দিচ্ছ? এটা নাও ওটা
Yes. This is important. Very important.
আমরা এসো হ্যাঁ জানবেন দরকার নেই
Yes. হ্যাঁ, তো other side বলে কেউ নেই। সবাই support.
বসো না তোমার দুইবার জায়গায় ডাক হবে না বসো
We are taking up that matter. 3:30.
Your Lordship. ওটা কবে করতে চাও কবে তোমরা বলো জজ সাহেবকে
Whatever day
my lord, the item number 9, my lord, I think my learned friends are appearing on the other side. I don't know what they want to.
DVC? Yes, what do you want?
My learned senior friend had already commenced his arguments. Before the other bench.
So what do you want? Tell us.
Lordship, if a date can be fixed, Lordship,
It's there in the list. It'll run we can't fix every matter by date and time. Dago 9:30, 12, 3:30.
Non-commercial matters, especially fixed matter, item number 54.
Wait, please, your lordship. My lord, this has given rise to an interesting question.
It's 283. 283.
283
Yes.
is the basic point, but my lord, the impugned judgment has gone into a lot of things. And to what extent your lordship would be pleased to, or rather, we should be following that. That is the issue. Well, I first of all, my lord, give your lordship, my lord, it's just a short background. My lord, this is the will of a gentleman who was residing in Raspberry Avenue. Well, this will be of importance. The properties which he had left, the moved properties which he had left behind, one property is situated in Baliganj area, that is outside the original ordinary civil jurisdiction of this court, and another property is in Delhi. There is a flat in Delhi. Well, the testator died leaving his widow and his two sons. My lord, the will was executed and the executor was appointed. My lord, when the application was made, all the beneficiaries under the will and the heirs and legal representatives signed and consented to the probate being granted. In a situation like this, insofar as our court is concerned, well, no citation needs to be issued. Citations are issued only when there is a possibility of contestation. So, in the facts of this case, my lord, no citation was issued. And, my lord, as this matter came up before the court as a uncontested will. Well, when the matter was there before the court, then a question arose as to whether, in respect of the Delhi property, any citation is to be issued. So our contention had been that there being no contestation in the will, all the beneficiaries having agreed and accepted and consented to the probate being granted, as to whether there is any necessity for issue of a citation, even in respect of a property which is situated in Delhi. Our submission had been that if you apply section 283 of the Indian Succession Act, there your lordship will be pleased to see lordship will be pleased to take the Indian Succession Act, section 283.
Is your client attending the conferences?
Yes, my lord. Thankfully, my lord, I have been able to persuade him to attend the conferences. In spite of reluctance, my lord, I had to, if I may say so with respect, my lord, I had to dangle some amount of carrot for the purpose of, my lord, persuading him to come to my chamber, and he did. My lord, kindly come to section 283, powers of a district judge. I shall take your lordship to some of the other provisions of this act also. Section 283 says powers of district judge. In all cases, the district judge or district delegate may, if he thinks proper, kindly note the words, if he thinks proper. This is the first thing that your lordship will please to note. A, examine the petitioner in person upon oath. B, require further evidence of the due execution of the will or the right of the petitioner to the letters of administration as the case may be. C is the important one. Issue citations calling upon all persons claiming to have any interest in the estate of the deceased to come and see the proceedings before the grant of probate or letters of administration. I pause here for a moment. Issue citations to whom? Issue citations calling upon the persons claiming to have any interest in the estate of the deceased. Now, if, my lord, the persons claiming to have interest in the estate of the deceased are all consenting to it, then, my lord, I don't have to issue citation to call upon them. Yes, signing, my lord, the consent thing. To come and see the proceeding before the grant of probate or letters of administration. Then 2, the citation shall be fixed up in some conspicuous part of the courthouse and also in the office of the collector of the district and otherwise published or made known in such manner as the judge or district delegate issuing the same may direct. Then, my lord, 3. This is the 3, my lord, this is the one that falls for your lordship's consideration. Where any portion of the assets has been stated by the petitioner to be situate within the jurisdiction of a district judge in another state, the district judge issuing the same shall cause a copy of the citation, well, kindly note the words, a copy of the citation to be sent to such other district judge who shall publish the same in the same manner as if it were a citation issued by himself and shall certify such publication to the district judge who issued the citation. So therefore, my lord, what it says is this: if, my lord, any portion of the assets of the testator is lying outside the in the jurisdiction of some other district judge, then it will be necessary for the district judge before whom the application has been made to send a copy of the citation which has been issued to the other district judge for being put on the property.
Provided citation is issued.
Provided citation is issued. So my short point was this, that if no citation is required to be issued, then, my lord, subsection 3 does not come into operation. And, my lord, my subsequent submission, my further submission had been that supposing, let us take for instance, deliberately somebody has suppressed that there is another beneficiary of the estate, or there is another will in respect of which, my lord, this particular testator has left his properties. Then what happens? My submission is this: there is a provision in the Act itself, section 263.
Revocation.
If there is, my lord, a citation is required to be issued to a person, and, my lord, it is not issued, then, my lord, he comes before the court and makes, my lord, an application under section 263. Kindly see this section 263. And the Supreme Court has said, has given, my lord, decisions on this particular point. Revocation or annulment for just cause. The grant of probate or the letter of administration may be revoked or annulled for just cause. Explanation. Just cause shall be deemed to exist where A, the proceedings to obtain the grant were defective in substance. It has been held, it has been, my lord, pronounced by the Supreme Court and by the High Courts as to what is meant by defective in substance. Or B, the grant was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case. Hereunder also one can come. C, or the grant was obtained by means of an untrue allegation of a fact essential in point of law to justify the grant, though such allegation was made in ignorance or inadvertently.
Mr. Mitra, illustration number 2 is absolutely clear.
Illustration number 2.
Under that section?
Under section 263?
Yes.
Yes. Yes, illustration. Yes, that's right. Your lordship, kindly see. Grant was made with the citing parties. Now, my lord, therefore, and in fact, my lord, in Supreme Court, the learned judge has relied upon some Supreme Court judgments where this exactly the same thing happened. Citation was not issued to the person who was entitled to citation. He came forward to the court. He said that citation has not been issued to me. This particular proceeding is defective in substance. Therefore, set it aside. There is one judgment of Mr. Justice S.B. Sinha presiding over the bench, his judgment, and there is another judgment, my lord, earlier of, I shall show to your lordship. There also, the same thing happened. Citation was not issued, and therefore, my lord, it was held to be defective in substance, set aside, and so that the person who is entitled to citation could come before the court and my lord, urge his point. My lord, this is the second thing that I wanted. Third thing, my lord, this is a short point I made before the court when, my lord, the matter came up for hearing. Unfortunately, in the impugned judgment, my lord, there is not a whisper of this. But the judgment has gone on to say a lot of things with regard to the jurisdiction of this honorable court. So much so that I find that a jurisdiction which perhaps this court has, that has also been negated. That is why, my lord, I am coming forward before your lordship to assail this judgment. This judgment has to be looked into by your lordship for the purpose of finding out as to whether this judgment should be sustained in respect of all the matters which had been discussed in this. This will be my one of the very important points. Well, your lordship knows the letters patent. Clause 34 of the letters patent, my lord, gives a special jurisdiction is conferred upon the high courts, the chartered high court, in respect of, my lord, granting of probate of evil. Well, I will request your lordship to look into that particular section before I take your lordship to the judgment.
Original side rules were very motor.
After this, my lord, I shall take your lordship into the City Civil Courts Act.
এরকম মোটা বইটা নেই আর ওদিকে থাকবে তো দেখো না।
In the High Court, my lord, shall I give your lordship a copy?
There is a copy. We have.
There is a copy. There is a copy. Ache? No, just wait. এটা দিয়ে দিন।
তাও
দিয়েছি, বসো।
আমাদের বই থাকে না কেন কোর্টে আমি বুঝি না কিছুতে।
My lord, besides this,
yes,
Rao has got it. Your lordship will please to come to clause 34. Testamentary and intestate jurisdiction. And we do further ordain that the said High Court of Judicature at Fort William in Bengal shall have the like power and authority as that which may now be lawfully exercised by the said High Court in relation to the granting of probate of the last will and testaments and letters of administration of the goods, chattels, credits, and all other effects whatsoever of persons dying intestate, whether within or without the Bengal division of the presidency of Fort William. My lord, kindly note these words. Of all other effects whatsoever of persons dying intestate, whether within or without the Bengal division of the presidency of Fort William, provided always that nothing in these letters patent contained shall interfere with the provisions of any law which has been made by competent legislative authority for India, by which power is given to any other court to grant such probates and letters of administration. Now, my lord, I pause here for a moment. Two things that I am emphasizing on. First is persons dying intestate, whether within or without the Bengal division of presidency of Fort William. Second thing I am referring, my lord, that this is a sacrosanct provision, but subject to any competent legislative authority, my lord, passing any law. This has to be, if it is curtailed, then it is curtailed. Third thing, my lord, I would request your lordship to take note of is that this clause 34 of the letters patent is confined to, my lord, this letters patent jurisdiction is, my lord, typically conferring jurisdiction on the High Court. Kindly note one very significant thing. Whether within or without the Bengal division of the presidency of Fort William, provided always nothing. So therefore, this is within the Bengal division of the presidency of Fort William. I have read it in this way that there may be corresponding provisions in the Madras and Bombay High Court also, similar type of provision. If that is so, then outside the presidency of Fort William, Bengal division, within or without the Bengal division of the presidency of Fort William, meaning thereby that so long as the property concerned does not fall within the jurisdiction of the two other chartered high courts, anywhere, my lord, if it is there, this court will have jurisdiction to that. This is a very wide power given to, especially, my lord, to the chartered high court. And my lord, I will be the last person to, my lord, advert before your lordship that there had been curtailment of this particular power, unless, my lord, I find there is a specific by which this provision has been curtailed. Otherwise, my lord, this remains. There are provisions, I shall show to your lordship, by which, my lord, to some extent, this has been curtailed. City Civil Court Act is one such. I shall presently draw your lordship's attention. Therefore, my lord, three things I am saying, that if a person dies intestate, all of the, my lord, kindly note the words, latest patent administration of the goods, chattels, credits, and all other effects whatsoever of persons dying intestate, whether within or without the Bengal division of presidency. Therefore, this is qualifying both goods, chattels, credits, and all other effects within or without the Bengal division. And, my lord, a person dying intestate within or without the Bengal division. Well, I will read it this way because, my lord, my submission will be that when this particular latest patent 1865 was promulgated, then, my lord, it was the intention of the legislature, the parliament, to give, my lord, the British parliament, to give power to these three high courts. I mean, I am talking of the Calcutta High Court now. The power to, my lord, give, my lord, grant probate or letters of administration in respect of goods, chattels, and credits, whether within or without, falling within, my lord, which is not within the domain of the other two chartered high courts. So this will be my respectful submission. Now, let us see to what extent the City Civil Court Act has, my lord, curtailed this power. The City Civil Court Act, which was 1953, my lord, had undergone a substantial amendment. Subsequently, my lord, in 2013. And, my lord, there had been curtailment of the power of the High Court in respect of very many matters. Lordship will please to come to section. Kindly come to section 2, subsection 3. City of Calcutta has been defined. City of Calcutta means the area comprised within the local limits for the time being of the ordinary original civil jurisdiction of the High Court. So that is City of Calcutta. Now, my lord, kindly come to section 5, which is a very important provision concerning the jurisdiction of the courts. Subsection 1 is the local limits of jurisdiction of the City Civil Court shall be the City of Calcutta. So, my lord, this particular jurisdiction is the ordinary original civil jurisdiction of the City Civil Court. Then, my lord, subject to the provisions of subsections 3 and 4, the City Civil Court shall have jurisdiction and the High Court shall not have jurisdiction to try suits and proceedings of a civil nature not exceeding rupees 10 lakhs in value. My lord, I am for the time being, my lord, ignoring the valuation. There is no dispute with regard to the valuation of this particular suit. It is more than 10 lakhs. So now it has become 1 crore. This rupees 10 lakhs is not 10 lakhs anymore. My lord, this happened, my lord, during this the present regime, my lord. The valuation was increased to rupees 1 crore. So this is what, my lord, city civil court shall have jurisdiction and the high court shall not have jurisdiction to try suits and proceedings of a civil nature, not exceeding the rupees 1 crore in value. And, my lord, this is within the local limits of jurisdiction of the city civil court, which is, my lord, city of Calcutta.
Yes.
Kindly come to the proviso. This is also very important. Provided that the city civil court and the high court at Calcutta shall have concurrent jurisdiction to try suits and proceedings of a civil nature, the value of which exceeds rupees 10 lakhs, it should be 1 crore, but does not rupees. My lord, now it is no. It has become
proviso to section
subsection 2 of section 5. Provided, kindly see, again I am reading subsection 2. Subject to the provisions of sections 3 and 4.
Here there is no proviso, the one we have been given.
No, this proviso is very important.
এটা দাও নাকি একবার দেখাও দেখাও
জসেফকে এইরকম একটা দুটো বই কিনে দাও, এটা না থাকলে হবে না। এখানে প্রয়োজন নেই, এটাতে নেই, তাহলে কি করবে হবে? Well, the proviso has come in. This is in 2013. The value had been increased, and my lord, it has become 1 crore. এখানে 1 crore কোথায় পাচ্ছ?
Not exceed rupees 1 crore.
No, not really. এটা 10 lakhs রয়েছে তো।
10 lakhs provided as
এটা 10 lakhs।
এটা পরে বেঁধে বলছে।
কে বললো তোমাকে? কোথায় পাচ্ছ? কোথায় পাচ্ছ সেটা? না 1 crore, this remains the same, 10 lakhs, and 1 crore হচ্ছে এইটা। Don't confuse. ভুল বলছো, এটা ওটা 1 crore হয়নি, এটা 1 crore হলে থাকতো এখানে। এটা দিস ভেরি ইম্পর্টেন্ট। এটা 1 crore, কোনটা 1 crore? প্রোভাইসোটা 1 crore। Like 10 lakhs in value, 10 lakhs কি আছে?
The amendment act is there, but that has the
এই প্রোভাইসোটা নেই মোটে এখানে। এটা কি লেটেস্ট? Well, I am proceeding on the basis of this. This is the, I am told is from the online, it has been downloaded. তোমার ওটাতে কি রয়েছে?
Amendment Act. Amendment Act does. Amendment Act provides
এটা কবেকার amendment act? 2013 আমার এখানে 2013 বলেই বলেছে।
আমি একবার এটার সঙ্গে কম্পেয়ার করে নিচ্ছি তাহলে প্রোভাইডেডটা দেখি।
ছেড়ে দাও তার আগে এটা কি?
এই প্রোভাইজোটা অ্যাড হয়েছে সেকশন 2 amendment-এ, provided the city civil court and high court shall have concurrent jurisdiction to try and value exceeds 10 lakhs but does not exceed 1 crore.
Concurrent, 10 to 1 crore is
Shall have concurrent jurisdiction. এইটা অ্যাড হয়েছে 2013-এ।
এদিকে এটা proviso
এইটা by notification.
provided that আর এখানে তার উপরেটা কি ছিল? 10 lakhs 10 lakhs টা amended হয়েছে।
হ্যাঁ।
Well, this is what it appears to be. No question of admitted. তুমি একটা provision দেখাচ্ছ that is not correct in one and correct in the other. Which one is
you
correct?
tell us now what is the pecuniary jurisdiction?
Concurrent jurisdiction from 10 lakh to 1 crore.
10 to 1 concurrent.
That's right.
Below 10 only city civil court.
Yes.
Above 1 crore.
Between 10 and 1, well, I remember this very well because
Between 10 and 1, both courts.
because in 2013 when this amendment was being incorporated, my lord, there was a, I don't know whether your lordships remember, there was a tremendous amount of controversy as to what is to be done. Then I happen to be one of the persons, my lord, who went by way of a delegation to meet the ministers, the state ministers, including, my lord, the chief minister, the law minister, the minister for municipal affairs,
Not finance minister.
home minister, finance minister. 5 of them were there. My lord, that this is somewhere near the Ruby Hospital. There is this office of Trinamool Congress. There, my lord, a meeting was held. The amendments were to be incorporated. And when, my lord, we went there, we said that you are completely denuding the High Court of the jurisdiction with regard to this. So you are making it 10 lakhs. The proviso was not there. This proviso, which was not there in the proposed amendment. Then, my lord, we requested, my lord, I remember Mr. Pratap Chatterjee went with me and 2 other persons, my lord, from the Bar Library Club. We went and we talked to them. And apparently, my lord, Chief Minister readily accepted this proposal. He said, what's wrong? If the City Civil Court and the Calcutta High Court have concurrent jurisdiction, let the litigants choose their forum, whether they want to go to City Civil Court or to the Calcutta High Court. And that was what, my lord, was spoken on the floor of the House. When this amendment was proposed, there was a controversy among the two. And the Chief Minister came out with this proposal that make these 2 concurrent and let the litigants choose. To which, my lord, the opposition didn't have anything to say. And thereafter, my lord, this proviso came into operation. That was in 2013. And proviso, my lord, kindly note this, subsection 2 says that subject to the provisions of 3 and 4, the City Civil Court shall have jurisdiction and the High Court shall not have jurisdiction to try suits and proceedings of civil nature not exceeding rupees 10 lakhs in value. So this is the value, my lord. If it is less than 10 lakhs or less, then, my lord, City Civil Court solely will have jurisdiction, exclusive jurisdiction. But, my lord, if it is between 10 lakhs and 1 crore, then there is a concurrent jurisdiction. If it is above 1 crore, High Court will have jurisdiction. So that is why the proviso says that provided the City Civil Court and the High Court at Calcutta shall have concurrent jurisdiction to try suits and proceedings of a civil nature, the value of which exceeds rupees 10 lakhs but does not exceed rupees 1 crore. Now, this has fallen for consideration before this court, and the courts have said 2 things. First is subsection 2. The main provision says, shall not jurisdiction try suits of a civil law. The local limits of the jurisdiction of City Civil Court shall be the city of Calcutta. So, my lord, these provisions were interpreted in this way that if the property or the person who is dying intestate is within the jurisdiction of the city of Calcutta, as defined in this, then my lord, city civil court will have exclusive jurisdiction. I am not considering, my lord, the pecuniary region, exclusive jurisdiction. Then, my lord, the Calcutta High Court has been completely denuded of its jurisdiction. But, my lord, if the person dying and the properties are outside the limits of Calcutta High Court, this is civil, my lord, city of Calcutta, then it is, if it is outside, then High Court will have jurisdiction. Even though it is outside, my lord, the limits of the city of Calcutta, High Court will have jurisdiction in respect of testamentary matters. If it is within, then only city civil court. If it is outside city, then my lord, High Court will have.
Within and outside?
Once it is within, then my lord, city court.
No, if one property is within, one outside?
No, but then if it is so, my lord, then Calcutta High Court will have jurisdiction. So in our case, my lord, the problem doesn't arise because, my lord, insofar as this case is concerned, both the testator lived outside the city of Calcutta and, well, the property was also outside city of Calcutta. So city court did not have jurisdiction and Calcutta High Court had jurisdiction. But kindly come to subsection 3. The city civil court shall have jurisdiction and the High Court shall not have jurisdiction to try any proceeding under
Indian Succession Act.
So Indian Succession Act has been excluded. So this has also come for consideration. I mean, there is apparent inconsistency between the two, subsection 2 and subsection 3. So how it is to be construed in respect of testamentary jurisdiction? Once, my lord, subsection 3 says Indian Succession Act is excluded from the High Court jurisdiction, then it goes out altogether. No, but this has been interpreted in this way. Clause 34 of the latest patent is there. You cannot ignore that. It has been interpreted in this way that if the property and the, my lord, the testator, the person who is dying, leaving the will, or an intestate, dying intestate, then if he is outside the city of Calcutta, then Calcutta High Court will also have jurisdiction. Even though, my lord, subsection 3 says that the city civil court shall have jurisdiction and the High Court shall not have jurisdiction in proceeding under in. This has been interpreted to mean that subsection 3 and subsection 2 are to be read together. What it says is this: previously under section 300, when Calcutta High Court had jurisdiction, that jurisdiction has been taken away insofar as the property is situated within the city of Calcutta. So that is the exclusionary clause under subsection 3. Your lordship now looks into if your lordship looks into, my lord, the Indian Succession Act section 100, section 300. Kindly see section 300. It says concurrent jurisdiction of High Court. The High Court shall have concurrent jurisdiction with the district judge in exercise of all powers hereby conferred upon the district judge. Now, my lord, this provision, section 300, is not there anymore so far as High Court is concerned in respect of property situated within the jurisdiction of the city of Calcutta. To that extent, it has been. Otherwise, if your lordship has again comes back to section clause 34 of the latest patent, this has conferred jurisdiction on the High Court of Judicature at Fort William, St. Bengal, for granting probate of the last will and testament and the letter of administration in respect of the goods, chattels, credits, and all other effects whatsoever of person dying is intestate, whether within or without Bengal division of the presidency. Fort William, provided always that. So, my lord, to the extent, my lord, section 5, subsection 2 and subsection 3 are read together. To that extent, my lord, the last part of the provision of clause 34 has come into operation, and to that extent there has been curtailment. The provisions contained therein, etc., with the provisions of any law which has been made by competent legislative authority for India, by which power is given to any other court to grant such probates and letters of administration. So, my lord, by City Civil Court Act, power has been given to the City Civil Court to grant such probate and letters of administration in respect of properties which is situated within jurisdiction. So, to that extent, my lord, the power of the High Court has been curtailed. Otherwise, the power of the High Court remains. Now, my lord, I am applying this principle. I shall show to your lordship the judgments on this point. My lord, I am applying this particular principle in the facts of our case. I am submitting to your lordship, my lord, that so long as clause 34 remains, I am proceeding on the basis that it has been excepting for curtailment to some extent of the power under clause 34, this power remains. Now, if this power remains, then, my lord, in my respectful submission, the High Court has the jurisdiction to grant probate in respect of an uncontested will, in respect of properties which are situated outside the limits of the City Civil Court at Calcutta and anywhere else outside, my lord, the Bengal division of the Precedents. So, if a flat is lying of the testator in Delhi and the property is in Baliganj and the testator dies in Baliganj, residing at Baliganj, and my lord, there he expires, then in my respectful submission, the High Court retains its jurisdiction for the purpose of granting probate of that particular will. And my lord, so far as this is one part of it, second aspect of it is
has the learned judge said that the High Court doesn't have jurisdiction?
Absolutely. I am, my lord, taking exception to that. And this, my lord, in my respectful submission, contrary to the earlier judgments which have been, though my lord referred to in this, but my lord, it has not been discussed that way. I shall immediately take your lordship to those judgments. My lord, there the court has very carefully analyzed these provisions and has come to the conclusion that the High Court retains jurisdiction in respect of properties which are lying outside the city of Calcutta, and my lord, in respect of probate of the will is being sought for. There the court has held that in a situation like this, Calcutta High Court has a full jurisdiction to entertain the proceedings and grant probate. But if it is within the jurisdiction of the City Civil Court at Calcutta, that is City of Calcutta, then, my lord, that is ordinary original civil jurisdiction, then, my lord, City Civil Court Act confers exclusive power, exclusive jurisdiction to the City Civil Court at Calcutta. Calcutta High Court's jurisdiction is ousted. To that extent, Section 300 is no longer, my lord, effective in respect of Calcutta. To that extent only. This provision, this is rather confusing. Unfortunately, this is the way it has gone on. But then again, my lord, the courts have been very clear as to how this is to operate.
This would be a perfectly harmonious interpretation of both the provisions.
Yes, well,
City Civil Court and LP, latest patent.
Well, I would respectfully submit to your lordship that is so. But, my lord, the funny thing is this, that insofar as the argument is concerned, I did not argue for more than 15 to 20 minutes. I confined myself to Section 283. I said that this is the practice, this is the High Court rules. My lord, High Court rules, my lord, I shall show to your lordship. That particular provision, Chapter 35, Rule 9. Which is, my lord, concerning testamentary and intestate jurisdiction of the High Court. There is a specific provision with regard to, in Rule 9, specific provision with regard to citation to rightful parties. There, on an application for letters of administration, unless otherwise ordered, a citation shall be issued to all persons having a right to take the grant prior or equal to that of the applicant, unless such person have signified their consent into the application. Well, this is, of course, I was curious why it is confined to the letters of administration. This particular provision, in fact, my lord, this practice is followed in respect of both probate as also letters of administration. I came to know from, my lord, from the solicitors who had been practicing in the original side, that it has been specifically mentioned with regard to the letters of administration is because in a will, that is in writing. So, my lord, the court knows who are the persons in whose favor the property has been left. In a letter of administration, there is no will. So, my lord, specific provision has been made in respect of letters of administration. But, my lord, both in respect of probate, grant of probate, and for letters of administration, the same, my lord, provision applies. No citation is issued if all the parties to the will sign, my lord, their consent. And if it is not so, my lord, this was my short submission. I said, if it is not so, then, my lord, in terms of section 283, no copy of citation can be issued. That was short, but, my lord, the learned judge had gone on to a lot of things which were not argued at all, unfortunately. I never had the occasion to, my lord, deal with this. Then, my lord, I would have told his lordship that this is the way that the judgments have gone. My lord, I tell you, lordship, my lord, the first judgment on this point was of Mrs. R.N. Pine. And that judgment is a very instructive judgment that has been followed. That was reported in 1984 to Calcutta High Court notes. I shall give your lordship a copy. Maybe the copy is not as good as it should be, because
compilations that are pending.
Here.
Compilation of all
Well, there are not all judgments. There are a few judgments. There are other judgments also which require. I find, my lord, Mr. A.C. Kaur appeared for the petitioner in that, and Mr. Prabir Raichaudhuri appeared for the state. Well, if I may place it, my lord, I think this judgment needs to be placed before your lordship in some details. Mrs. Pine's judgment in the goods of Shailendranath Sarkar. Shailendranath Sarkar, hereinafter referred to as the said deceased, a Hindu governed by Dayabhaga School of Hindu Law of Indian domicile and an inhabitant of Ramkrishnapur, Howrah, outside the ordinary original civil jurisdiction of the High Court, but within the testamentary jurisdiction of the District Court of Howrah, died on 30th December 1982, leaving a will and testament dated 18th of November 1981. The said deceased died leaving his 5 sons, his widow, Srimati Durgarani Sarkar, and 1 daughter, Srimati Priti Mitra. By and under the said will, the said deceased appointed his 2 sons, namely Shochidulal Sarkar and Nirodbaran Sarkar, as joint executors and trustees. The said deceased left properties all within the jurisdiction of the court of the District Judge, Howrah. So, my lord, he lived in Howrah and left his properties within the jurisdiction of Howrah. Then, my lord, kindly come to the next paragraph is with regard to the application of probate of the will and the City Civil Court Amendment Act of 1980. Then, my lord, kindly see that's a sentence. In connection with the said question, with the paragraph 2, let me place paragraph 2 also. The petitioner Shochidulal Sarkar and Nirupan Sarkar, having made an application to this honorable court for grant of probate of the said will, a question had arisen as to whether, after amendment of the City Civil Court Act 1953 by the City Civil Court Amendment Act of 1980, this court has jurisdiction to grant probate of the said will. In connection with the said question, a broader question has arisen in this case as to how far the jurisdiction of the High Court to grant probate and letters of administration under the Indian Succession Act 1925, as also under clause 34 of the latest patent, has been effected in view of the amendment of the City Civil Court Act 1953 by the City Civil Court Amendment Act of 1980. The submissions were made before me by the learned counsel appearing on behalf of the petitioner and the state of West Bengal, respectively. Then, my lord, it has been submitted on behalf of the petitioners that City Civil Court Act 1953, as amended by the City Civil Court Amendment Act of 1980, is restricted in its application within the territorial jurisdiction of the City Civil Court, which under Section 2, subsection 3, is the City of Calcutta, and the same includes the areas comprised within the local limits for the time being of the ordinary original civil jurisdiction of the High Court. It is submitted that if the place of abode at the time of death or the assets left by the deceased are outside the territorial jurisdiction of the City Civil Court, then the amendment made in the City Civil Court Act cannot affect the jurisdiction of the district judges of other courts who have concurrent jurisdiction with the High Court at Calcutta. It is for other cases, the High Court also retains jurisdiction under clause 34 of the latest patent, unless it can be shown that there is a specific negation of such power and jurisdiction of the High Court by any other special statute. It has also been submitted that even after the amendment of the City Civil Court Act, as aforesaid, the High Court retains its testamentary jurisdiction in all cases except where the testator dies, having a place of abode within the territorial jurisdiction of the City Civil Court Act, and also has left assets within the jurisdiction of that court valued at less than rupees 1 lakh. So, my lord, both things are to be, this was the argument which was made, that he had to live at the place of abode has to be within, and also the properties will have to be within. Then, my lord, on behalf of the petitioner, reference has been made to 264, 266, 270, etc., for the purpose of showing that the territorial and pecuniary jurisdiction of the district court, when deceased dies, leaving assets within the jurisdiction. Here, perhaps your lordship can make a note of it, that under the Indian Succession Act, a district judge has been defined as a judge of a principal civil court of original jurisdiction. So, my lord, High Court also, in that sense, under the Indian Succession Act, is a district court. Then, my lord, kindly come to, I am not traveling your lordship, I'm taking your lordship straight to the judgment decision. For the submission, I am not, lordship will be pleased to come to para 16. The question that arises for consideration is to what extent High Court's power and jurisdiction to grant probate and letters of administration has been affected by the City Civil Court Amendment Act of 1980. Before dealing with this question, the provisions of the Act having a bearing on the question may be referred to. Then Section 2BB, Indian Succession Act, district judge means the judge of a principal civil court of original jurisdiction. Then Section 264 of the Indian Succession Act provides the district judge shall have jurisdiction in granting and revoking probates and letters of administration in all cases within his district. Then Section 266 of the Indian Succession Act provides that the district judge shall have like powers and authority in relation to the granting of probate and letters of administration and all matters connected therewith, as are by law vested in him in relation to any civil suit or proceeding pending in this court. Then Section 270 of the Indian Succession Act provides that the probate of the will or letters of administration to the estate of the deceased person may be granted by a district judge under the seal of his court, if it appears by petition verified as hereinafter provided of the person applying for the same, that the testator or intestate as the case may be, at the time of his decease, had a fixed place of abode or any property movable or immovable within the jurisdiction of the court of the judge. Then Section 271 of the Indian Succession Act provides for disposal of the application made to judge of district in which the deceased has no place of abode. Then Section 272 Indian Succession Act provides about the conclusiveness of the probate and letters of administration. proviso to the said section provides that probates and letters of administration granted by a high court or omitted by the second schedule of the City Civil Code Amendment Act by a district judge, where the deceased at the time of his death had a fixed place of abode situated within the jurisdiction of such judge, and such judge certifies that the value of the property and estate affected beyond the limits of the jurisdiction does not exceed rupees 10,000 at that point of time, shall. Then 295 of the Succession Act. Then, my lord, it has gone on that the different provisions City Civil Court have been enumerated here. Then, my lord, kindly come to para 30. In view of amended section 5 of the City Civil Court Act, in cases where the deceased dies, leaving a fixed place of abode and has left properties within the jurisdiction of the City Civil Court, that is the City of Calcutta, which means the area comprised within the local limits of for the time being of the ordinary original civil jurisdiction of the High Court, only the City Civil Court has the jurisdiction to grant probate or letter of administration. It is contended by the petitioner that the pecuniary jurisdiction of the City Civil Court in such cases is only up to rupees 1 lakh, and beyond that limit, the jurisdiction of the High Court has not been effected. I am unable to accept such contention. Section 5, subsection 2 of City Civil Court Act as amended, which specifies pecuniary limits up to rupees 1 lakh, is subject to subsection 3, 4 and 5. Section 3 and 4 of Section 5. By amended Section 5.3, exclusive jurisdiction has been given to the City Civil Court to try any proceeding inter alia under the Indian Succession Act, arising within the territorial jurisdiction of the City Civil Court. With regard to the proceeding under various acts mentioned in subsection 3, which includes Indian Succession Act, the pecuniary jurisdiction of the City Civil Court is not limited, because subsection 2 of section 5 is subject to the provisions of subsection 3 and 4 of that section. Hence, in my view, High Court's jurisdiction and power to try proceeding in respect of cases under Indian Succession Act arising exclusively within the territorial jurisdiction of the City Civil Court has been completely taken away by the City Civil Court Amendment Act 1980 and conferred on the City Civil Court. The intention of the legislature is clear, and such proceeding will be tried by the City Civil Court exclusively. The next question is, what is the effect of omission of Section 300 of the Indian Succession Act by second schedule of the City Civil Court Amendment Act 1980? By Section 300 of the Indian Succession Act 1925, High Court has been conferred concurrent jurisdiction with the district judge in the exercise of all powers conferred upon the district judge by the Act. Since Section 300 is omitted without any qualification, it cannot be said that the omission of Section 300 is limited only to the cases triable by the City Civil Court. In my view, omission of Section 300 has deprived the High Court's concurrent jurisdiction not only in respect of matters triable by the City Civil Court, but in respect of jurisdiction exercisable under the Indian Succession Act by the district judges throughout the state of West Bengal. The omission of Section 300 is not subject to any qualification or limitation, but is absolute. Excepting the provisions of the Indian Succession Act, which are omitted by City Civil Court Amendment Act of 1980, if any power or jurisdiction which has been conferred upon the High Court by any provision of the Indian Succession Act, that power or jurisdiction can be exercised by the High Court in respect whereof the City Civil Court has no exclusive jurisdiction. So this is, my lord, the pronouncement. And I think, my lord, this is the salutary pronouncement which has been made. I am also unable to accept the petitioner's submission, as stated earlier, that Section 5, subsection 3 of the City Civil Court Act uses the expression proceeding and not suit. And therefore, when the probate proceeding is contested and is marked as contentious cause, it becomes a suit under the provisions of Section 295 of the Indian Succession Act. As also under Schedule 2, Item 1G, proviso of the West Bengal Court Fees Act, 1970. And if the valuation is over rupees 1 lakh, City Civil Court's jurisdiction is ousted. Then para 34. Under section 295 of the Indian Succession Act, in any case, if there is contention, it does not become a suit. If there is something is missed out. In such case, the proceedings shall take as nearly as may be the form of a regular suit according to the provisions of Code of Civil Procedure 1998, in which the petitioner for probate and letters of administration, as the case may be, shall be the plaintiff, and the person who has appeared to oppose the grant shall be the defendant. Hence, when an application for grant of probate or letter of administration is opposed, the proceeding does not become a suit, but it is treated as a suit. The exercise of the power by city civil court for grant of probate or letters of administration is by an application in exercise of the original jurisdiction, is not arising out of a suit. Hence, it is a proceeding as defined by section 2, subsection 5 of the City Civil Code. Well, what was argued is this: once it has become a suit, therefore it's not a proceeding. The court negated that. Court said no. It remained a proceeding in the nature of a suit. Then, my lord, the exercise of power by city civil court for grant of probate or letter of administration is by an application in exercise of the original jurisdiction, not arising out of a suit, and hence it is a proceeding as defined in section 2, subsection 5 of the City Civil Code Act. In this connection, a reference may be made to Rule 28 of Chapter 35 of the original side rules of the Calcutta High Court. The said rule provides that upon the affidavit is in support of the caveat being filed, the proceedings shall, by order of the judge, upon application by summons, be numbered as a suit in which the petitioner for probate or letter of administration shall be the plaintiff and the caveator shall be the defendant. The petition for probate or letters of administration being registered as and deemed as a plaint filed against the caveator, and the affidavit filed by the caveator being treated as a written statement in the suit. The court is saying this is a procedural provision only. In the case of Bora Kanayala, etc., the High Court, referring to Section 83 of the Probate and Administration Act, said this. Well, I am not troubling your lordship with this because it is nobody's contention. It is not a suit. It is a proceeding. Then, my lord, your lordship is
Not much time is left. When is it convenient? Tell us.
Your lordship, my convenience is your lordship's convenience. Whenever your lordship wants.
Wednesday, perhaps 3:30.
But I am told on Wednesday it is 3:30.
Wednesday, there's a full court reference.
Court reference. At 3:15, your lordship will authorize.
Haka?
On Thursday.
Thursday, 3:30.
Your lordship.
But in the original side, item number 17, I appear for the appellant.
Which one?
In item number 17, my lord.
I mean,
the heading appeal from But tomorrow and day after, for a personal reason, I have to be out of town.
Non-commercial.
Non-commercial.
Non-commercial, বলছেন.
This was in non-commercial. In the originals, non-commercial originals.
Yes, who is on your other side?
Mrs. Banerjee, I think. Noel Banerjee. I will.
Noel Banerjee. Inform her.
I'll inform her.
কি বলছেন দেখো কবে থাকবেন না ওটা
Tomorrow and day after, I will not be there. Thereafter.
মিস্টার এটাতে কি আগের দিনের কোনো অর্ডার আছে?
কালকে আর
অর্ডারের ফাইলটা দাও।
করা যায় 3:30 যদি বাই চান্স হয়ে যায় একটু রিকোয়েস্ট করবেন।
But can it be on that day, on Thursday, your lordship is pleased to fix at 3:30? I am always apprehensive of 3:30.
Not on a Thursday. Wednesday, Friday definitely, but maybe Wednesday.
Very well, my lord. We shall take our chance.
কোথায় কি দিলে? Mr. Mitro, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph lists this matter once again on Brihspatibarer Tarikh din, marked 3:30 p.m.
I have my lord's time leave to mention item number 41
My lord, that matter is analogous to the matter that was being heard, my lord. Same order, my lord, on the basis of which an order was by supplementary proceeding. If that matter could also appear on Thursday at 3:30, my lord.
Well, a number of matters.
All the matters which involve similar point, same point, give a list. They'll be listed one after the other together. একসময় করে দেবে সব।